This appeal hearing is in the matter of CFI 009-2023 and CFI 005-2016 and is being held by way of video conference before Chief Justice Zaki Azmi. The claimants are represented by HFW Middle East. Lead counsel is Mr. Sharif Shifji, KC. The defendants are represented by Jones Day. Lead counsel is Ms. Heather Martin. Any orders or directions made during or after the conclusion of this hearing will be issued on the judge's instructions by the registry in Dubai. Thank you.
9 a.m. London. By the way, I'm in London too. So, Mr. Sharif, and Miss Heather.
Miss Heather.
Heather.
Good morning, Your Honor.
Yeah, morning. Okay, this is an application for permission to appeal, isn't it?
Correct.
You have requested to be heard. In person. So here we are today. Normally, 90% of these cases is heard on paper. Nevertheless, Mr. Sharif, you got 3 basic grounds, right? 3 basic grounds for reasons why permission should be granted.
These are the defendant's grounds, Your Honor.
Your Honor, I'm the respondent to this application.
Oh, sorry. Yeah, pardon. I beg your pardon.
Okay, Miss Heather's application.
Yeah, Miss Heather.
But that's right. She has 3
basic grounds to broad grounds. So, okay, let's start with it then. Okay, please.
Sure. The first ground is that the court should grant appeal on the extension of time for service granted to claimants. And if I first may thank the court for granting a hearing on this permission to appeal application before proceeding. The court of first instance committed 3 separate errors in its determination of the issue of the extension of time for service, giving the defendants a real prospect of success for 3 separate reasons, any one of which is sufficient grounds for this court to reverse the lower court's decision. First, the lower court failed to consider the prejudice to defendants of losing a potential statute of limitations defense regarding the insolvency claims. Second, the lower court failed to require claimants to meet the legal standard of putting forth good reasons supported by evidence for their delay in effecting service. And third, the lower court improperly shifted the burden to the defendants to have accepted service via solicitors and/or expedited the diplomatic service in advance of the legal deadlines that actually applied to the defendants by virtue of the Swiss courts, rather than maintaining the burden on claimants alone to have proceeded apace in effecting service, despite lacking any support in the law whatsoever for such an approach. Granting an appeal on the service point is further necessary for clarity. With respect, Justice Cook's approach represents a significant departure from any common law precedent that we were able to find. One only need look at how lawyers will be left to advise their clients in the wake of his order. In the absence of binding DIFC authority, setting forth the proper standard under Rule 7.22, the advice will need to be that in the DIFC, claimants bear no responsibility to take reasonable steps to effect service prior to the last day of the service period, but instead the defendants must accept service before the claimant's deadline or risk bearing the cost of the claimant's application. The RDC Rule 7.22 is nearly identical to the CPR Rule 7.6 subsection 2. Of England and Wales. And as for the requirements of an extension of time application, the RDC is, in some ways, it does go further than the CPR, suggesting to litigants that claimants in the DIFC are held to a higher standard than in England and Wales. That is the opposite of what happened here. So taking each of these 3 points in turn. First, the real prospect of success on the extension of time prejudice point. The law of England and Wales is clear that the prospect of losing a statute of limitations defense affects a prejudice on defendants and is a reason the court should decline and not that they should grant an application.
So Ms. Heather, let me understand this. You are saying that if the claim was not served within 6 months, that's the limitation you're talking about, isn't it?
Yes.
The 6 months,
Correct.
months to serve. If they fail to serve that, then he would have lost his right to the suit. But here, the Judge Jeremy gave an extension retrospectively. and that's what you're complaining about.
Correct. So the application, or I'm sorry, the application and claim form and particulars of claim were filed on February 1st, if I remember correctly. I'm sure Mr. Shivji will correct me if I'm not right. But later that month, the limitations period expired on the insolvency claims.
Expired. When was the date expired? 6 months. I remember it was 6 months, and then it was something like 4 months, 2 months left, or something like that.
Well, the expiration date for the limitations period for them to have filed their claims, and please, Mr. Shivji, correct me if I'm wrong, but I recall it being the 16th of February.
16th of February.
Okay. So, well, we don't agree with that, but I think the date Your Lordship, Your Honour, was after was the 1st of August. So the claim form expired after 6 months on the 1st of August of this year, and we wanted an extension effectively of a week, and it was a prospective application. So we got our application in before the deadline. It wasn't a retrospective application. It was a prospective one.
Thank you. I was actually seeking your confirmation of a different date, which you did put in your pleadings, which is that the insolvency claims limitation period did run in February.
I just want to know, because I read through whatever I got there. What is not stated, of course, if I had dug in deeper, I would have got the answer maybe. What is the original, the real claim, the substantive claim by the Sarasin Bank against the defendants? There must be some debt or something like that. Is it for the repayment of a loan? Isn't it? I assume, because it's a bank.
So I'm sorry, you're talking about BSA, the claimant in this case?
Yes, yes.
So BSA is a plaintiff in what is essentially an insolvency related action.
Insolvency related.
Correct.
Okay, insolvency. Okay.
So the reason that we have two separate matters is because it issued some claims that sound in fraud against some of its former directors and one of its former officers, as well as its majority parent company and a company under common control. And it, together with its liquidator, says that business was transferred away from it to what we're calling the fifth defendant here, which is the company under common control of the former majority shareholder.
Yes. Okay.
So, sorry.
So
please.
when you are referring to the time limitation, are you referring to the 6 months time limitation, or are you referring to the time that they have to file in for insolvency or fraud? What is the limitation you're referring to?
Sure. So
the period of limitation.
The period of limitations that we are concerned about is on the insolvency claims, because they do not sound in fraud, and so they are subject to a 6-year statute of limitations.
Okay, 6 years limitation. 6 years limitation, and that ends when?
I believe on the count that
is it relevant? Is it relevant to the issue for us? That's all I want to know. If it's not relevant, then we just
absolutely, because this is the prejudice that we're complaining about, is that if the claim form expired, then the defendants have at least the individual defendants have a good argument that the limitations period also expired along with the claim form, and that by extending the time to serve the claim form, it effectively acted to extend the statute of limitations.
This is the 6 months. The 6 months claim form you're talking about.
So the 6 month.
They're supposed to serve the 6 months within. the claim form within 6 months.
Correct.
They could have served they tried to serve in Switzerland, in Geneva. They got the order, but the defendant's lawyers refused to come and collect the document from the courts or something like that.
Well, they didn't have instructions to collect it from the courts, and the clients were under no obligation to give instructions. They were under a deadline from the courts.
But Miss Heather, I'm sorry to keep on interrupting you.
No problem.
But isn't this a question of discretion by the judge? The judge has taken everything into consideration and arrived at discretion, because this sort of thing, extension of time, is normally discretionary on the judge. This, after taking into consideration, of course, judicial discretion, of course, in arriving at this discretion, is it's difficult for the Court of Appeal to go and tell and say that the judge had erred in, in this sort of discretionary matters.
Well, of course, it is a discretionary matter, but discretion still needs to be guided by the law.
Yes,
and
that's
the
why
law,
I say judicial discretion. Yeah.
But the discretion, again, in this case, a litigant and a party in this jurisdiction would have expected the court to adhere to the law governing the use of discretion in these cases, which includes that the court needs to consider all of the evidence before it. The court did have evidence before it and statements from both parties that a statute of limitations would have expired in February if the claimants had not served the claim form and application then. The court didn't grapple with that fact at all in coming to its decision, and it is a fact that it needed to grapple with.
Go on. Yes.
All right. So there is, as I mentioned, copious case law on this, and I would like to bring a couple of cases to the court's attention.
Yes.
The first of those is Actas versus Adepta, and I'm going to draw the court's attention to page 1358 of the bundle.
Yeah.
At paragraph 91. It's a 2010 decision of the Court of Appeals, and the court will note that a lot of the case law on the CPR comes from this time period because it's right within a couple of years after the CPR got enacted, which changed the scheme in England and Wales for extensions of time. But what I'd like to draw the court's attention to is that the court's observation there that the reason why failure to serve in time has always been dealt with strictly, even before the further tightening under the CPR, is, in my judgment, bound up with the fact that in England, unlike all or most civil law jurisdictions, proceedings are commenced when issued and not when served. In such a system, it is important, therefore, that the courts strictly regulate the period granted for service. If it were otherwise, the statutory limitation period could be made elastic at the whim or sloppiness of the claimant or his solicitors. For the same reason, the argument that if late service were not permitted, the claimant would lose his claim because it would become time barred becomes a barren excuse. Turning the court's attention to another case, the law of England and Wales is further clear that a defendant need not demonstrably prove the deprivation of a statute of limitations defense at this stage. Rather, in Hodinot versus Persimmon Homes, this is at page 1271, at paragraph 52.
Yeah, go on.
The court observed that where there is a doubt as to whether a claim has become time barred since the date on which the claim form was issued, it is not appropriate to seek to resolve the issue on an application to extend time for service or an application to set aside an extension of time for service. In such a case,
what is the doubt here in this our present case? What is the doubt you're referring to?
I will let Mr. Shiji make his own arguments, but I understand their argument to be that they were under no obligation to serve the application in the insolvency matter, and therefore the statute of limitation, the extension of time isn't effective as to that particular application. We dispute that because the insolvency claims were included in the claim form, but in any event, what this case says is that this form is not the appropriate form to resolve that dispute.
Yes,
drawing the court's attention to a third case, City and General Holborn, which is at page 1364 of the bundle, paragraph 7.
Yeah.
The Court of Appeals echoed this statement and added, if the claimant's argument that the claims are not time barred is correct, they can always begin a fresh action in which, if a time bar is asserted, it can be adjudicated upon. It is enough for a defendant to show that he might be deprived of a defense of limitation if time for service of a claim form is extended. If he can show that, an extension of time should not be granted.
Okay, can you relate those facts to the case, the present case before us?
Sure.
How do you relate them?
So the claim form and the case and application were filed on the 1st of February by the claimants. The statute of limitations as to the insolvency claims expired on the 21st of February, according to the claimant's own pleadings, so 21 days later. The claimants had 6 months from the 1st of February to August 1st to serve the claim form. And if they did not do so within that time period, absent an extension, then the claim would have gone stale and the statute of limitations on the insolvency claims would have expired.
Yeah, but what I'm trying to say, how do you relate that to the facts of the case that you just cited to me? Can you just sort of compare the two and tell me?
I have honestly cited this case for its general principles, but if I can.
How did you connect the two, the case that you cited to the facts of our case, so that I can say, wow, almost on all fours or similar or something like that? That's all that I want from you.
Sure. Could I have a minute just to grab my paper copies? I'm a bit old-fashioned and work on paper.
Sure, please do. I'm also struggling with this thing. Well, what I'm trying to say is the defense, Mr. Sharif, will of course be trying to distinguish the facts of the previous case with the facts of the case before us now, while you will be trying to show similarities, and that is what I want from you. Can you show the similarities of the two cases? That's all that I want from you.
Well, so the primary similarity is that the application in that case was made shortly before the expiry of the limitations period, and the defendants applied
the reason for extension in those cases and the case before us.
Well, because the application was made without notice there, and so the application was to set aside the extension.
How do you distinguish that the case before?
What we would say is that the principles that the court is discussing here apply here, and Mr. Shibji has not attempted to grapple with these principles at all, despite them being cited in our skeleton argument. So I will be interested to hear what he has to say about distinguishing it. What we would point to, though, is that in the DIFC, we found no controlling authority that was decided on the basis of a Rule 722 application. The 2022 DIFC Court of Appeal case in Khoury versus Mashrek Bank noted in the context where no such application had been filed that where an application is filed, the conditions for the rules must be met. It further noted in paragraph 54 that the rules leave no room for recourse to any freestanding principle of reasonableness. Were such a course open to a party who had failed to comply with the applicable time limit, the time limit provision would be gravely undermined. That is at page 1983 of the bundle, and that is paragraph 54.
1983. Okay. Yeah.
And it was further argued before that case by Mr. Montague Smith that there is nothing unjust in the application of a strict time limit in a case such as where wholly unexplained service of the claim form had been left to the last minute. These are all principles that this court recognized, again, in a case where the issue was not, strictly speaking, on a Rule 722 application. But on the equities of a strict approach, it paraphrased the English authorities that we've been through. And if we could go to paragraph 50, page before.
50, yeah, okay. This is the judgment you're citing from. Okay. By contrast, the English authorities lend no support whatever to any such freestanding principle. General provisions permitting extensions of time in CPR could not be relied upon to override specific limitation on applications for the extension of time. Given the need to guard against excessive cost and delay, there was nothing unjust in the existence of strict time limits, especially where service of claim form had been left to the last minute. You are saying this is left to the last minute?
They certainly delayed approximately 4 of the 6 months. They recited certain chronological events that took place, but didn't really explain the delay. They said they needed to obtain funding, but they didn't say how much. They said that they had to wait for translations.
So Ms. Heather, sorry, while I'm asking you a lot of questions, I'm also learning the law, that's my admission to you. So what you're saying that, to me, I may be wrong, please tell me I'm wrong, that whether it's 1 month or 2 months or 3 days, the last minute, the term last minute, is it 1 day, 3 days, or 3 months? Isn't that the discretion for the judge to decide? That's what I meant. When you say, I want to know what is the last minute in Vinos and what is the last minute in the Ideal Shopping. If you help me there, then it makes my life easier to make a decision.
Sure. The law is absolutely consistent that this is.
Yeah, on facts
Sure.
here, when you talk strict time limits and has been left to the last minute, is 6 months the last minute? Is 3 days the last minute?
I think it depends on the circumstances, and in circumstances where there is no treaty between the UAE and Switzerland, which the claimants were surely aware of from day one, because they'd been sitting with this claim for 6 years, and including a 1-year period in which the statute of limitations was told due to a standstill. They still waited 4 months to seek the court's assistance for diplomatic service. That's really unreasonable in the circumstances. Now, if this were, for instance, when England and Wales was a member of the EU and they had service into France, you'll see other cases discussing that it's reasonable to leave it until you have 3 weeks left, because typically 3 weeks was plenty of time because they had treaties that assisted them with service. But no such treaty existed here. This was well known to the claimants, who were advised by counsel who have an office in Switzerland, who were able to give them that advice very early in the service period, and yet there's still an unexplained delay until May.
And they are banks, they have professionals to advise them.
Well, it's a liquidator. It's a liquidator and the company.
And they're professional. They're professionals.
He's appointed by the court, so
yes,
he's an officer. He's an officer of the court who we would expect greater diligence from.
Okay, go on.
Well, I'll finish up on this point and move on to the second point.
Sorry, I'm taking a lot longer than expected because, as I said, I'm asking you a lot of questions.
I'm quite happy. I'm quite happy to satisfy the court's questions.
Okay, thank you very much.
If it is this court's intention to depart from these cases and this authority, the DIFC cases currently provide no clarity that the potential prejudice to a limitations defense is not a factor for the court's consideration. Thus, in any event, the Court of Appeals should grant permission to appeal and provide the legal community with clarity so that we can properly advise our clients. So moving on to the second point, which is the burden shifting point. Again, talking about the clarity of the law of England and Wales, it is clear that defendants...
So on this point, you are asking for the compelling reasons. You're asking on grounds of compelling reasons why this permission should be given, not just, although you didn't mention it in your appeal, your permission to appeal. The reason why you're asking to determine the law, what the law in Dubai, the IFC is, you are therefore relying on the second limb of 44.19, i.e. compelling reasons. Okay.
Both the first and second limb. I do believe that we mentioned it in our
Did you? Okay.
in our in the skeleton on behalf of the individual defendants.
Okay. Yeah. Compelling reasons. Yeah. Okay. I put the note.
So the law of England and Wales is clear that defendant's conduct is not the focus of an inquiry into whether claimants have offered good reasons for the granting of an extension of time. On a standard in which claimants must justify their own delay without reference to the defendants, this appeal has a real prospect of success and is not the standard the lower court applied. The court instead entirely focused on the defendant's conduct, stating that it does not lie in the mouth of an uncooperative defendant who is fully aware of the claims made against it and who is seeking to gain advantage by being uncooperative to complain at an extension of time sought and obtained by a claimant who needs it because the delay inherent in the process of service through diplomatic judicial channels. That is quoting from paragraph 14 of the September reasons, which he essentially adopted as to the individual defendants as well in paragraph, I believe, 12 of the October reasons. Now, this approach is contrary both to principle and authority, which are both bases for challenging a discretionary decision. The principle, which is reflected in the court rules, is that it is the claimant's burden to justify an extension of time where they have failed to comply with the generous time limits provided by the court rules. Justice Cook acknowledged but failed to apply this principle, instead imposing upon the individual defendants the obligation to assist the claimants to complete service of the claim form before it went stale. The English courts have rejected an approach that focused on the defendant's acceptance or not of service in at least 3 cases. The first case is a Supreme Court case called Barton versus Wright-Hassel. And here I am referring to page 1838, paragraph 23.
Eighteen.
1838.
Okay, please go on.
So if you refer somewhat to the middle of the paragraph, it talks about a person who courts disaster in this way. And this way being having issued the claim form at the very end of the limitation period, as here, 21 days before it, and opted not to have it served by the court. And in this case, of course, claimants had no option but to have it served by the court, but they waited 4 months for that. And then made no attempt to serve it himself until the very end of his period of validity. So the service rules being somewhat different in England and Wales make the actual mechanics of service somewhat inapplicable to these facts and circumstances where diplomatic service was required. But the principle, again, is the same. This same principle is reflected in multiple other decisions, including the Court of Appeals.
I note in passing that Mr. Burton had made no attempt whatsoever to serve the claim form, but simply allowed it to expire. An application to extend his life would have failed because it could not have been said that he had taken all reasonable steps to comply with Rule 7.5, but has been unable to do so. Again, how do you compare these facts to the facts before us? It's different.
Again,
it's the discretion, the different type of discretion. I'm not being difficult for you. I'm just trying to understand.
Absolutely.
Because I must confess to you, I'm a Malaysian, although our laws are almost similar, but you're very familiar with the CPR, which is similar to the Dubai, the IFC, RDC, but English principal law is still English principal law, whether you come from Singapore or Malaysia or Hong Kong. So that is why I'm taking a bit slower to understand. I'm very, very sorry about that. I apologize very much.
We're very happy to go. We're very happy to
Okay,
go through
yeah.
it slowly with you.
Yes.
I think what might assist the court is to look at some other cases just so that the court can
Yes.
see the consistency
Yes.
in the approach of
Find
the
a
other
case which is
cases.
similar to the facts you have, then it's easier for me to make a decision.
All right. Well,
This is
let's look.
Lord Samshed is a very highly respected judge.
Sure.
Okay.
Sure.
Yeah.
So, I would, if the court were to only read one case, I would honestly ask it to read Barton versus Wright Hassel because it is a Supreme Court case, and I do think that the principles that it sets forth would assist the court.
What is the principle? What before he came to that statement? Oh my God! Before he came to that statement, what? Oh my God! Before he came to that statement, what did Lord Samshed say? How did he come to arrive at that statement? I'm sure he discussed the points below. Should I touch the wrong thing?
The principle is that it is the claimant's burden to effect service, and that the burden should not be shifted to the defendants. You can't put the burden on defendants to accept service in circumstances where the claimants didn't do everything themselves.
I think the judge considered that in his judgment.
Yeah. But perhaps if we moved on to Al-Zahra
Yes,
Hospital.
please go.
And I would take the court to page 1865, paragraph 89.
Yeah, 1865. Okay. Yeah, please continue.
So again, this sets forth similar principles that that's found that the judge erred in placing weight on the fact that the defendants had not responded to communications from the claimant seeking their cooperation to complete service, and that the claimant had failed the judge had failed sufficiently to take account of significant periods of delay where the explanation was unsatisfactory. So this stands both for the principle that the burden should not be shifted to defendants to cure claimants' delay in service, but also that the claimants need to explain and evidence their own delay. We'll come to that in greater detail in the third appeal point.
Okay.
And then the third case, again, just to show what the body of law states, is Qatar Investment and Projects Holding. And I would direct the court's attention to page 1886, paragraph 42.
What paragraph? Okay, go on. Paragraph 42, did you say? Yeah.
Yeah, paragraph 42, and I'm just trying to find my place within the paragraph where it says that
the layman's ensured it was quite correct. At 6 months, you wish to serve the claim form out of jurisdiction, it's necessary to emphasize better part. Steps. This is similar to your facts, I think.
Yeah, I think that
closer to your facts.
Yeah, I
closer
believe
to
that
the facts for us. Okay, go on.
So I would direct the court's attention to sort of in the middle of the paragraph, I think fourth line from the top of page 1886, where it begins, however, as the master observed, the claimants took an optimistic view of the attitude of the defendant company's solicitors to accepting service, which is similar to what happened here. Clifford Chance were still representing the defendants at the point in time, or they were believed to be representing the defendants at the point in time, according to HFW. And so HFW had emailed Clifford Chance asking them if they would accept service, which Clifford Chance responded to and said that they were not instructed to accept service. The date of that was 23 May. So again, if you count back to the date on which the claims were issued, that's
so in Qatar, what was the conclusion in Qatar? What was the order? The extension was refused. Extension was refused, is it?
It was refused, and it was an overturn of the discretion of the master.
Oh, the paragraph in judgment dealing with the effects of pandemics.
Not sure that's right, actually.
Oh, sorry, apologies.
Conclusion: since there is no reason for me to conclude the matter fell into error, or principle for me to find the decision was outside the scope of discretion. The appeal was, this is what I've been trying to drive to you, Mr. Hassan. This is what I've been trying to drive. Discretion. Yes,
yeah,
not
so
outside
in
the
that,
scope of discretion.
just to correct what my learned friend said on that, in that case, the master had granted an extension, and then the appeal was refused.
That is what I've been driving from the beginning. I'm sorry. I've not made my decision yet. I must confess to you, but okay, go on.
We would ask this court to reject a defendant-centric approach because it would upend RDC 9.53 provision imposing on the serving party the obligation of ensuring he complies with the rules regarding service of the place where he is seeking to effect service. So here, according to that rule, by serving in Switzerland, the claimants were obligated to serve consistent with Swiss requirements. But what the court did here is said, rather than the defendants playing whatever role they played in requiring that they were required to play by the Swiss courts in their participation of accepting that service, which was to pick them up from the court by, I think it was the 9th of August, they needed to meet the claimant's deadline for them. This is very confusing for parties when they have the courts of their own sovereign country setting deadlines for them, and the courts of another country saying, no, it is your obligation to meet another party's deadline. That is not in the interest of justice to have these competing deadlines imposed on parties that they don't actually even apply to. And it cannot be what the drafters of the RDC had in mind when adopting the English standard for extensions of time, as it ignores the strict standard applied by the courts of England and Wales, requiring good reasons for the claimant's delay. Looking at the practical...
You've got a very strong American accent. Are you an American?
I am an American.
Okay. Okay, go ahead. Yeah, please go on. Go on to the next point. You can go to the next point, I think.
Okay, sure. So the third appeal point on extension of time is on the legal standard applied. Again, while there is discretion, the law of England and Wales is clear that when considering whether claimants have put forth good reasons supported by evidence for the granting of an extension of time, those good reasons must include a demonstration of the reasonable steps they took, including the reasons for any delay. There is no debate about the parties believing this to be the relevant standard. It is also the standard that the claimant cited in the courts below, although in this court, they have turned their attention almost exclusively to an exceptional case of ST versus Bay. Now, on the good reason standard, the defendant's appeal has a real prospect of success because the court just ignored it. It just waved off the claimant's 4 months of delay as window dressing, instead ascribing the failure of timely service to a 1-week period in which the court believed the defendants should have assisted the claimants. Now, this is seen in the statement that whatever the initial delay, didn't give any mind to it whatsoever. And that is in paragraph 12 of the September order and 14 of the November order. And his resort to a just standard is tantamount to the freestanding principle of reasonableness that this court explicitly rejected just last year in Corey versus Mashreq Bank. Again, this is contrary to principle and authority. The principle, which is reflected in the court rules, is that it is the claimant's burden to justify an extension of time where they have failed to comply with the generous time limits provided for in these rules. The authorities are those previously cited, as well as a case called Cecil versus Bayat. And I would refer the court to page 1391, paragraph 108.
There's 1391.
Mm-hmm.
1391. Okay, go on.
So the English Court of Appeals observed that a claimant who applies for an extension of time before the expiry of the period should be held to show good reasons when a defendant's limitation may be prejudiced, and as such, why he does not bear responsibility for delays in service. The lower court here required the claimants to show neither, instead applying a standard of what it considered to be just, which imposed no accountability on claimants and functionally acted as a freestanding principle of reasonableness. As applied by the English courts, good reasons comes with a menu of requirements they're fact-driven but shaped by legal guidance, and each requires the court to evaluate the claimant's diligence in pursuing service. And we count there to be 4 requirements. The first one being that a defendant's awareness of a claim is not a substitute for service. And that is another principle reflected in the Supreme Court case, Barton versus Wright-Hassel. The second is that a claimant cannot excuse his delay in circumstances where he has courted disaster by his own inaction. The third is that a claimant must explain his delay. And this is a matter that Cecil unpacks helpfully for the court. So if we can look at paragraph 38, it's particularly informative as to the explanation required when the proffered need to secure funding is a source of delay. And that is on page 1375.
Okay. Sourcing funding. Okay. Please proceed.
So there, the Court of Appeals declined to grant an extension of time when the inquiries remained outstanding, such as what was the nature, amount, or purpose of the funding was not stated and has not been since. That is similar to the facts here, in that the claimants gave no further explanation as to what was the nature, amount, or purpose of the funding required. And that case goes on to note that a case is not exceptional, such that good reasons need not be shown, and good reasons require explanation. Here, however, the claimants submitted witness statements chronologizing their delay without explaining it, but the lower court did not hold them to a standard requiring explanation, effectively treating the case as exceptional. Now, fourth, the court must then scrutinize those reasons put forward by the claimant. And to facilitate the scrutiny, the claimant, again, correspondingly, must submit evidence of the good reasons for his delay. In Fornan versus Secret Surgery, which is an English High Court case, page 1668 at paragraph 45.
1668. Hang on. 1668, paragraph 5. Okay. Paragraph 1668, paragraph 45. 45. Okay. It's the Woolf statement.
The court declined to find good reasons required by evidence beyond a witness statement. There, the court declined an application for extension because the statement of reasons was brief and no relevant correspondence or documentary evidence was exhibited to it. That is also the case here. And if we could take you to just show the evidence, it's page 475, which is the witness statement in question. It's 477 and 478, apologies. So we go to paragraph 24.
Yes.
So the claimants told the court that in the period commencing 8 February, so a week after filing, they sought advice about the requirements for service in Switzerland. So they certainly learned by then that diplomatic service was required. Now, an unexplained 2 months goes by before they started approaching translation firms. And it takes you through some of the machinations they went through in getting translations. But again, no documents were attached to this, providing evidence as required by this case. So we have a lot of explanation on translations, and then there is a paragraph in here where they state that they were seeking funding as well. And that's in paragraph 36, which is at page 482. And here, they even acknowledge that they understand that the English Court of Appeal held in Cecil versus Bayat that an extension of time to serve a claim form was not justified where the claimant had delayed serving the claim form so that they could arrange funding, and extending time would deprive the defendants of a limitations defense. On these facts, the level of scrutiny that the court applied to this cannot justify its decision because there was no real scrutiny applied. Again, this is a chronologizing of the delay without actually explaining it. Why did they wait 2 months to do anything? Why did they wait 4 months to seek the court's assistance? Why did they not attach documents to their witness statement? Why did they not substantiate the funding that they were seeking? Now,
these arguments, I'm sure, had been raised before Justice Jeremy, hasn't it? The grounds that you have just mentioned to you just now, I'm sure
yes.
had been raised before Jeremy.
But then if you read his decision, he doesn't really grapple with them. And here, in terms of the case law, the claimants also don't grapple with it. They instead cite this case, ST versus Bay. I hope I'm saying that correctly, which we can find at pages starting at page 1997.
1997.
The thing the court should also be aware of in terms of what Justice Cook did and did not consider is on this issue in the first hearing, he did not let me speak. He didn't let you speak. He did not.
He didn't let you speak.
Correct. He let the claimant's counsel speak, and then he immediately ruled. And I attempted to put our points into the record retrospectively, quite ineffectively, I think. But then that set the precedent for the second hearing regarding the individual defendants. So where I didn't have an opportunity to advocate on these points as forcefully, we did on paper, we believe, but it was quite difficult to make our points during the hearing.
Yeah, I mean, the Justice Jeremy, I know him. I've sat with him many times. Very, very fast decision maker. Makes decision very fast. Okay, go on. Yeah, so you were citing this case just now, 1997. What is it that you want to mention here?
So this is a case that the claimants heavily rely on, and we do acknowledge that the courts sometimes treat cases as exceptional where they do not require a statement of good reasons. And I think that the lack of imposing good reasons on this particular claimant are on the balance of equities of the case. No doubt motivated by the fact that she was a sexual assault victim and a 69-year-old former police officer who, on a relatively short statute of limitations, I think a year or two, was attempting to get her claim served during the height of the pandemic and couldn't find a French huissier, which I interpret to mean a process server. So if the court were to adopt the approach used here, used in ST, it would merit explaining to the legal community why it is adopting such an outlier rather than the approach reflected in the bulk of English law cases.
Okay. Yes, Ms. Shatter.
So it is a case of physical impossibility, whereas we just certainly don't have those circumstances here. The lower court's approach here is a complete departure from the approach of the English courts in circumstances where the RDC is a copy-paste of the CPR. And this departure from what should be the presumed precedent in circumstances renders the lower court's decision plainly wrong, giving the defendant's appeal a real prospect of success. This departure also merits explanation to the legal community. Yet the reasons for this departure were never explained, as is obvious from the fact that the court did not cite a single case precedent in its reasons. This approach thrusts into the DIFC court system a level of uncertainty that is wholly unacceptable in a common law jurisdiction, and does so on important foundational issues, and is a further reason for this court to grant permission to appeal.
Okay.
I would just one last note that the need to exercise scrutiny is not discretionary. That is a mandatory requirement of the court's diligence in these cases. And discretionary decisions are overturned for failure to take into account relevant facts.
I think discretionary principle is that if any judge in the same position, no judge facing a similar position would have arrived at that decision. That is the principle. No judge facing a similar situation or considering same facts would have arrived at that conclusion.
That is
then that discretion was not correctly exercised. That's
that
what
is
I learned.
under
Yeah.
the plainly wrong standard. That is correct, but there are other standards that need to be met on discretion, and one is that the decision cannot be contrary to principle, which we argue that all three of these are. The judge cannot fail to take account of relevant facts, which on all of these we say that the judge did. The judge cannot take account of irrelevant facts, which we would argue that shifting the burden to the claimants does. Those are all errors that merit reversal, even on discretionary decisions.
Okay. Yeah, go to the next, your second ground.
Okay. Could we just get the court's the court would prefer that we move on to the Liz Pendon's point rather than have Mr. Sheep. Oh, all right. So
I would rather you submit all 3 points, and then Mr. Sharif can reply to all 3 points.
All right. Well, we know that Liz Alibi Pendants has a real prospect of success on appeal because the court has previously said in Horizon, in respect of insurance proceedings that were not mandatory court proceedings, as with the Swiss proceedings here, that it had a real prospect of success.
Okay,
and therefore,
Ms. Heather,
yes,
please help me. Teach me what is the basic of lease pendants. I've learned this. I've forgotten the principle of lease pendants. I know what it means, but can you guide me from the beginning, please?
Certainly. Now,
Okay,
Mr. Shivji quarrels with me about whether or not is a doctrine, but this court is actually has called it a doctrine, and therefore we refer to it as a doctrine.
Okay, let's say doctrine.
It is Latin, and it means suit pending elsewhere.
Yes, I know that. I know what it means, suit pending elsewhere. But when and how does the court exercise discretion, and in the situation, as if I can use the word lease pendants, face a case of which you are now arguing, when does the court exercise a discretion that it should go to the original court and not this court? Because there's another case pending. Yeah.
There is no decision of this court stating that it is a discretion. That's correct. Either stating that it is a discretionary decision or that it is a mandatory decision. This court simply hasn't taken it up. But looking at other court systems, most relevantly here, Switzerland, Liz Alibi Pendants is a statutory matter in Switzerland. And what the courts there say is that essentially if it is a first filed proceeding in a competent court, between the same parties and involving the same matter, then the first filed court has presumed jurisdiction over the matter.
That is the Swiss law. What about the English law?
Right. So the English law, can I take you through a bit of a history lesson? Because that's
Yes,
what I
please,
actually
please,
think
please, please. That's what
is,
I need from you.
Sure. So what I would say about the majesty of the common law is that it adapts over time, frequently through arguments that are unpopular the first time they are presented. And so this is precisely how the English doctrines for declining jurisdiction have evolved over time, separately as forum non-conveniens and lis alibi pendens, separate doctrines. You may have seen reference in both of our pleadings to a case called Spiliata. It is a very important case.
Yes.
So it is the seminal case on forum non-conveniens in England and Wales. It was decided in 1987. And I'm going to take you up to the history of Spiliata, because again, forum non-conveniens and lis alibi pendens were on dual tracks through and including that case, actually. But over 9 years before the House of Lords adopted this, what was then the Scottish doctrine of forum non-conveniens and Spiliata, a nearly identical argument was put to the House of Lords. And a sort of fun fact about that is that Lord Gough was actually the, or then I guess Mr. Gough QC, argued it in a case called Atlantic Star. It was unanimously rejected. And then it was his speech in Spiliata that is cited as having adopted the standard in forum non-conveniens cases.
So when he became a judge.
Correct.
When he became a judge, he introduced the same argument. Okay.
Correct. Or he became a, I think, fruitful audience for that same argument is a good way to put it. So one, trying to get this in the right order here. So over time, as I stated, the doctrines of forum non-conveniens and lis alibi pendens have developed in parallel. And the sort of seminal case in which the English courts were first able to decline jurisdiction over matters on lis pendens was called the Christianberg. It's an 1885 case. I'm not really relying on it. I'm just giving you an anchor so that the court can follow through this history. Those doctrines, again, developed in parallel up until I think it's the 1940s, when there was another case called St. Pierre, and that brought them essentially under the same test, but it's a different test than exists today. It basically said that the English courts are going to exercise jurisdiction unless trying the case in England and Wales would be vexatious or oppressive, right? So it was really, really, really tough to get rid of a case in England under that standard. And what that standard really represented was what the courts have since called the chauvinism of the English system. Basically, the English courts thinking that they're the best, and so everybody should have a right to an audience before them. But in the 19th,
it's still happening today, and that's what Dubai Court is trying to do as well. Everything must come before the IFC.
Everything must come. Okay. Well, I understand you have a mandate from the government, but we still need to apply legal principles to that exercise of jurisdiction.
Yes.
Now, the 1970s began, and if you think about what was going on in the world in the 1970s and where the English Empire had reached at that point, that began a movement to adopt a different test. And it was then Mr. Gough QC who advocated for liberalizing the standard in a case called Atlantic Star, and to move away from the imperialistic views that England had of itself and its the place of its courts in the world. He criticized the English court's preoccupation with upholding the plaintiff's right to initiate proceedings in England, including because it went against international comity. And his argument was to adopt the Scottish and American model. As you can probably imagine, this suggestion was bold. That's a polite term. Lord Wilberforce called it radical. And it was also unanimously rejected in that case. But notwithstanding that rejection, many members of the House of Lords recognized and criticized the inherent sense of superiority in the English-centric approach. and the need to update it. And those efforts resulted in a modified form of the Scottish form of non-convenience doctrine under Spiliota less than 40 years ago in 1987. But Spiliota did not address Liz alibi pendants cases. Only after Spiliota was decided in another House of Lords case called de Dampierre versus de Dampierre, so a divorce case, Lord Gough confirmed that the Spiliota formulation provided the basis for the court's decision to relinquish their jurisdiction in both forum non-convenience and Liz alibi pendants cases. This court has not adopted the de Dampierre standard, and the claimants neither cite to it nor argue it in this court that this court should adopt it. Thus, the Liz alibi pendants question remains open in this court. And another important fact to bear in mind as through is that in 1987, the same year as Spiliota, it also marked the Brussels regime coming into force, which in turn caused the courts separately by the standalone doctrine of Liz pendants, by virtue of the Brussels regime and Lugano Convention, to apply the doctrine separately. Thus, Spiliota became obsolete almost immediately after its adoption in any case where parties to litigation from the European Union member states, and whenever the defendant was domiciled in the United Kingdom. So the period of its obsolescence in those cases only just ended, meaning Spiliota has been stunted in its natural ability to evolve and adapt for the past 40 years. So all of this is to say a couple of things. There's exponentially more history and support in English law for applying the two doctrines of Liz alibi pendants and forum non-convenience in parallel than there is for the DIFC wedding itself exclusively to Liz alibi pendants being given the same treatment as forum non-convenience, which when viewed in its historical context has only existed exclusively in England and Wales for 2 years and is likely to keep evolving. Now, Spiliota, again, the radical case that it was the right move for the English courts at the right time, in so much as it was a meaningful move away from imperialism and lack of international perspective that the English courts had previously exhibited. That context should be viewed by this court as a license to decide for itself whether Liz alibi pendants should be addressed under Spiliota test or should be given a more categorical treatment to suit the jurisdictional values of this court as an international court, featured as part of the DIFC infrastructure to attract foreign investment. And returning to the law of this court, it has left open the application of Liz alibi pendants in a case called Albuherra National Insurance Company versus Horizon. And if I could take the court to pages 1874 and 75 of the bundle.
1874.
Your Honour, I'm sorry to interrupt, but I'm just looking at the time, and I was just wondering how long Your Honour has today, because at the moment I think just over halfway through.
I have all the time. I know we set only 2 hours for this. I realize that, and now with 1 hour we have passed 1 hour 15. No, 1 hour 5 minutes, almost 1 hour 5 minutes. Never mind, don't worry, Mr. Sharif. I will allow you, unless you are rushing off somewhere, you got other appointments to keep after this.
That's kind of you to ask, but I'm available, so I'm happy to stay. But I will need a bit of time with you.
Miss Heather?
I'm available for the duration of the afternoon.
Okay. Please be patient with me, because as I said, I'm being very honest with you. When I'm not clear, I will ask you. I don't want to be left having to start reading myself all over again when you are there to help me to understand the law. So, but I promise you, Mr. Sharif, Miss Heather has covered a lot. They cleared a lot of doubts in my mind regarding the law. So I think you can move faster, I think.
Yes, I mean, it won't surprise you to hear that I don't agree with much of what she said.
It's up to you.
But I can take you through why that's wrong.
Don't worry. You are there not to agree, so don't worry about it. Okay, thank you very much. Please go ahead. I think you can go through this very fast. You can actually tackle both the ground 2 and 3 together. I think they're about the similar principles.
They're sort of the flip side of the same coin. I think that that's
so
true.
You can go faster on those two grounds. Okay,
so
please.
I just wanted to take you to this court's consideration of Liz alibi pendants in the past, which has always seemed interesting to it, but it's never quite gotten off the ground. So if we go to paragraph 46, this is in the court of first instance.
1997, is it?
I'm sorry, 1874 or 5? 4.
1874. Okay. Yeah, go ahead. Paragraph?
Paragraph 46.
46, okay. Go ahead. Horizon referred to okay.
No, sorry, this is actually, I think is this the right? Oh, yes, this is the right one. Sorry, there are several Horizon decisions in the bundle. So if we go to the last sentence, and just to give the court the background on some facts here there was a question raised about whether or not proceedings issued before an insurance authority within the UAE constituted a Liz alibi pendants. And so it was decided on the facts of those particular type of proceedings that no, they did not. But the court was clearly curious about it. And this last sentence states, other questions could be asked about the relationship between the doctrine and forum non-conveniens, and the doctrine being Liz alibi pendants, because it had defined it in the paragraph earlier. And its place in the
reference to other decisions to the same effect and decisions tribunal whose decisions were given as Horizon submitted that the authority by its committees was to be regarded as judicial body whose proceedings were least benefit. Okay.
So the other questions could be asked about the relationship between the two doctrines and their place in the UAE judicial systems. So those were the remarks of the court of first instance. Now, if we could just quickly take you to the remarks of the order granting appeal, which is page 1995, paragraph 16.
1995, 16, yes.
Didn't give much explanation, but clearly found it interesting enough to say that there's at least an issue about whether or not the judge erred in concluding that engaging the dispute resolution procedure, again, an insurance related procedure, set out in Article 110 could not constitute a basis for the application of the Liz alibi pendants doctrine, that ground was allowed on the basis that it had a real prospect of success.
So what happened to the appeal?
So
has the appeal been heard?
So the appeal was heard, and for reasons that we don't know, because we don't have access to the pleadings, it was actually not put forward by the defendants in those cases. But what I would say is that those defendants were instructed by HFW, who are the opposing solicitors in this case. So one must think that they believe that this issue, at least in some circumstances, has a real prospect of success on appeal before this court. And one has to think that it is stronger grounds to say that there is a previously filed pending proceeding between the same parties concerning the same subject matter in the courts of a sophisticated country, Switzerland here, than simply an administrative type dispute filed before an agency within the UAE.
Okay.
Now, if I could address a couple.
Whose judgment was this? Who heard this in the first instance?
I believe it was the then Chief Justice.
Michael Huang. No, Azmi.
Badni?
Dismissing the first PTA. Upon the order dismissing the first PTA, upon second seeking permission to appeal, I refused the first PTA, but on appeal,
that's right,
was allowed.
It was before Justice Giles at first instance. I believe that Justice Giles then retired, and the question of first instance permission then came to Your Honour, and I think that was in August of last year. Your Honour may remember that, and actually Your Honour refused permission on all grounds, including this ground. But
Yes.
I can address you on that when I come to my submissions.
And then I didn't hear the appeal because I decided on the PTA. I
That's
decided
right.
not to hear the appeal because I sat as like I had to see Roger Giles that retired. Yes, okay, go on.
So the claimants have cited a couple of cases, Union Insurance and IGPL versus Standard Chartered Bank, as rendering the open door on Liz Alibi Pendens shut. But those cases involve other matters in courts of the UAE, and the cases are clear that that cases in other matters of the in other courts of the UAE do not receive forum nonconvenience treatment. So that really has nothing to do with Liz Alibi Pendens vis-a-vis a foreign proceeding. And in fact, we did a pretty thorough scrub of the law here, and we didn't find any case in which the court had really grappled with this issue. There was one case, KBC. I'll find the reference to it. Pardon me for the pause here. We have the first page of the, 2096 is the case that I would, or the page that I would direct the court to.
Yeah. Yeah.
And what the court was grappling with there was an absence of proceedings anywhere else. Apparently there was some sort of threat to file proceedings in Canada, or at least Canada was being put forward as another available forum, but there were no pending proceedings there. And so the court really hasn't decided a matter when it was faced with this situation. Interestingly, in that case as well, also decided by Justice Cook, he was very concerned with the prospect for inconsistent outcomes in deciding that case. But when it came to this case, he essentially said that the prospect of inconsistent outcomes was just something that we were going to have to live with.
So basically here again, you are going more on compelling reason because the principles of lease alibi pendants is not well established yet in the DIFC courts.
Going on both grounds, Your Honor, we do believe it has a good prospect of success, but also on compelling reasons. I can take the court through the standard that I think it should adopt and the basis for it, but if that's not appropriate at this procedural posture, I can move a little faster.
Yeah, please proceed faster.
All right. Then we would just say summarily then that there is a basis in the unidrop principles for the standard that we would put forward, and that adopting a clear and categorical rule on Liz Alibi Pendens would have the dual advantages of clarity for litigants and of evidencing the DIFC court's character as a truly international court. There are, of course, relevant facts here about whether or not this court would give the Swiss proceedings Liz Alibi Pendens. This is where there's an English case, Lehman Brothers, that says that Swiss conciliation proceedings, such as were filed here, do deserve the treatment of Liz Alibi Pendens. And so I will not take the court through that in detail, but that is in our pleadings. It's also, the Lehman case is also a matter that was discussed in the Horizon matter by this court. Now, just talking about forum nonconvenience, if the court is not minded to consider Liz Alibi Pendens as a standalone doctrine, Does the court want me to take it through
foreign non-convenience is quite well established in the IFC, I think. They've been discussed in a number of cases.
It has been discussed in a number of cases. I would say in a majority of those cases that we were able to find that it was discussed in the context of whether or not it would apply as to other UAE cases. The answer that we take it to be no, but also those are inapplicable here, and never when there's been another pending proceeding in a foreign court. Just a couple of things that I would ask the court to grapple with in a forum non-convenience analysis, because forum non-convenience is not a principle that's applied uniformly in all common law jurisdictions. And while this court has determined that the English formulation, not the Australian formulation, of the clearly inappropriate forum test applies, there are open questions. So two key examples is, and this was one that was actually raised by Justice Cook, is what effect, if any, does it have in this court that the forum non-convenience test essentially bakes into it the English service standards, right? So claimants in England and Wales don't have a right to serve out of jurisdiction automatically. They have to apply to the court for that. And so the burden is on them in the first instance to establish that that service out is proper. So it stands to reason that when it comes to forum non-convenience analysis, because some burden has already been undertaken by the claimant, that the defendant has to bear the entire burden on a forum non-convenience analysis. We don't have that circumstance here, and that was actually a question specifically put to the parties in the first hearing regarding the fourth and fifth defendant, and that's at page 251 of the bundle of the transcript. I won't give you the quote, but it's sort of long, but it sums up at the end stating where service is not of right, then the burden essentially rests on the person serving. I asked the question, how does that work in the DIFC context? Is there any authority on point, and does it really matter? Those questions were not actually answered at that hearing, and he didn't make findings on them as part of his judgment.
But you're quite well aware that a judge doesn't have to decide every point raised by parties in arriving at this decision. A. B. A judge also is not required to give detailed reasons for arriving at conclusions. You know, that is the way the English law works.
Certainly,
you know,
and that's
yes.
And none of what I'm saying is a criticism of Justice Cook in this regard. I would say that it's a question that he put to the parties in KBC as well, also didn't resolve it there. So the fact that one of the court's own jurists is repeatedly asking this question and asking if there's any guidance on it suggests to us that it's a question that deserves to be addressed by the court so that there is guidance, because it's certainly relevant to parties to know who bears the burden and why.
Okay.
The second point that I would ask the court to take into consideration in a forum non-convenience analysis is what is the importance of public interest factors in the DIFC, because those include comity. And so the reason that this comes up is because somewhere like the United States explicitly considers public interest factors, whereas Australian, Canadian, and English decisions downplay them. I will give the court a citation without taking it to that so that we're not taking up so much time, but there's a case Luba versus Cape. It is in the bundle at pages 1082 through 1105 and at paragraph E on page 1098 of the bundle. The court here, again, this being England and Wales, stated that it actually pays really no attention to public interest factors that aren't specifically connected to the parties. So this court, it's a different juridical character than the English courts, which are national courts. And so being an international court, should it pay attention to comity, where it is essentially thereby showing respect to the courts of other nations? That is a question that this court should grapple with.
This case is filed in the IFC only because, filed in the in the Geneva, the claim is okay. I'm trying to recollect what the facts are. This is an action regarding insolvency by the Swiss bank, isn't it?
So it's
Against the defendants who are in the IFC.
No,
Is
so
that
it's
it? No.
it's a claim involving insolvency of a DIFC entity that was 60% owned by the Swiss bank.
Okay.
And so the questions or the allegations rather that are raised in the consolidated particulars of claim state that the former directors and one former officer breached their duties and did so in concert with the Swiss bank.
Yes, thank you. I remember now. So when you're talking about lease alibi pendants and foreign non-convenience, you are saying what? That this case should be heard in Switzerland instead of the IFC? Is that what you say?
Correct. Case there was filed on the 21st of January. Whereas this case was filed on the 1st of February. It involves, oh, sorry, the 19th of January, not the 21st.
Sorry, 19th of January in the IFC.
No, 19th of January in Geneva.
19th of January 2023 in Geneva. And then the one in the IFC?
1st of February.
1st of February 2023.
Correct.
February 2023. So you are saying that the case filed in Geneva was earlier than the one filed in the IFC.
Correct. Now, right? I expect Mr. Shivji to make much ado about the fact that there was a standstill agreement in place that prevented the claimants from filing their claims during that period, but it did not prevent the defendants from filing claims during that period. That standstill agreement was heavily negotiated, including specifically the provision that unilaterally allowed defendants to file claims. And so to the extent they got surprised by the filing of claims during the standstill agreement, it's really just because they were poorly advised on that point, and they shouldn't be made to complain to this court about it. It's not for this court to fix it.
What did the judge say in respect of that matter?
I don't recall that the judge really took that point on board. But I would also expect the claimants to complain that they didn't receive a formal letter before action in respect of the Swiss claims, but that's not the standard practice in Switzerland. And so by stating that they had an expectation of receiving one, really what they're saying is that they expected to, I guess, apply the standards of the DIFC to Swiss courts litigation.
Okay. I think that's, I think you've covered well enough. Anyway, you have put everything in writing as well. So that's it. Ms. Heather, is there anything else you want to say?
There was a question before the court of first instance about whether or not the courts of Geneva would exercise jurisdiction over these claims. And when only the evidence of the Swiss bank and its wholly owned DIFC subsidiary were in, there was more of an outstanding question because it didn't show where a lot of the activities alleged took place. Once the evidence was filed by the individual defendants and that hearing went forward, the court essentially allowed the assumption that the courts of Geneva were an available forum.
Were available.
Correct.
Were available. Okay.
Correct.
We'll entertain the claim. That's what you're saying. Okay.
Correct. So, and as I made the argument, he on multiple occasions, I think 3, said, let's just assume that for the sake of argument. So he did not quarrel with that proposition here. So to the extent the claimants are arguing that Geneva is not an available forum, I would ask the court not to revisit that particular finding because the court allowed it to be assumed.
Okay.
That's
it. Can I hear Mr. Sharif now? Do you want to take any break? Short break, 5 minutes? I don't know. I'll leave it to you.
I'm fine. If your honour's happy to go ahead, I am. But I want obviously you to be comfortable. So
okay, give me 3 minutes, 5 minutes. I'm going to just close the but I'm not going to turn off. Just 2 minutes. No 2 minutes.
Okay.
Sambungan. Betul. Sampai. My second device battery is running out. I have to do to connect the battery. Okay, yes, please, Mr. Sharif.
I'm very grateful, Your Honour. This case is all about, these applications are all about the court in which this case should proceed. And the difference between the parties is that the claimants say the case should proceed in the DIFC, and the defendants say that the case should proceed in the Geneva court in Switzerland. The judge's critical finding was that it was clear that the centre of gravity of this dispute is in the DIFC. And that was paragraph 28 of his judgment. I don't need you to turn that up, but that is his key finding. And we say that was a perfectly reasonable decision for the judge to reach in the exercise of his discretion. And the reasons behind his finding are sound and unimpeachable.
What was the reason? What was the reason he gave for that? For holding that he should be in the IFC? And he went through. Okay. It's not just the signing. There are so many other factors that relate the parties to the IFC rather than he went through that. Okay,
that's right. So there are a number of different aspects to this. They were the nature of the claims, DIFC law claims, the nature of the parties, primarily DIFC parties, the nature of the likely issues at trial, which have a DIFC focus, and some other matters to do with actually how these proceedings come about and how they're being administered. So I wanted just to start by explaining that. So what I was going to do in my submissions was take you through 4 points that really go across all of the grounds of appeal. And then we will look at the grounds, those 3 grounds separately.
Yeah, but before, to me, can you point out this paragraph 28 for me again? I read through it, but I'd like to,
of course, that's
because
page 180.
To me is one of the critical points of for me to decide, I think.
Yes, of course, exactly.
What page is that?
Page 185.
185. 185.
And it's paragraph 28. And he says, can you see that all in all, it is clear to me that the centre of gravity of this dispute is in the DIFC?
Yeah.
Has Your Honour got that?
All in all, clear it is here, the centre of gravity there. The connections only are not as strong as those we have seen in nature. There was question of service only in Switzerland, but everything else is in something like that. Yeah. Okay. Yes. I read through this, but I can't remember.
I'm grateful. There's a lot of material that the judge saw, and over the course of all of these applications, we had a total of 2 days before the judge.
So, Mr. Sharif,
Yes.
If the judge had decided on facts, that this is so, then the issue of lis alibi pedentis and forum wrong convenience doesn't apply anymore, isn't it, on the facts of this case? On the facts,
exactly.
Irrespective of what the law is, unless the judge was wrong in interpretation of the law. But as I said, the law on the forum non-inconvenience in DIFC is quite well established. It's only the other one, the lis alibi pedentis, which is, I don't know how relevant it is to this case. Okay, just go ahead.
So your Honour is landed on exactly the key point. The judge made this assessment after 2 days. He made this in total after 2 days of hearing, with probably about 2 days of pre-reading the judge had done in a bundle that ran to several thousand pages. He had done a huge amount of reading. He heard the parties at great length. And I know that Ms. Martin said that she wasn't heard on a particular point, but that isn't right. The judge, at the end of both hearings, the judge gave the parties an opportunity to say anything that they wanted to say. So her clients had a proper opportunity to make all of their submissions. And the judge ended up coming to this assessment based on his analysis of the facts. And there is, in fact, no serious dispute between the parties on the law. And many of the authorities that were cited by Ms. Martin were also cited by us, and many of the passages she pointed to, we also took the judge to. And so when it actually comes down, although I don't agree with her analysis of lis pendens, and I'll explain why once one looks at authorities that we're clearly right, there was no serious issue of law between the judge. And this case is a perfectly orthodox application of the law, where the judge reached that decision, as I said, for 2 days of hearing based on the facts. Now, I'm just going to develop that submission a bit further to show Your Honour why these submissions are sound that I'm making. And I wanted to start by doing that by reference to 4 overarching points. The first point is a point about the nature of the claims and the nature of the parties. And it is really important for the court to understand what this case is about, because that in itself shines a light on why the judge said the centre of gravity was the DIFC. So this case, in some respects, follows on from the Carafi litigation, the Carafi mis-selling litigation, which Your Honour has probably come across from time to time. And in that case, an investor sued 2 banks. One of those banks was my client, the first claimant, and the other was the 4th defendant in this proceedings, the Swiss bank. And essentially, Sir John Chadwick made orders for damages against both defendants in substantial sums in respect of investment mis-selling. And he also ordered on top a sum of further $35 million to be paid by my client, the first claimant. And the first claimant wasn't in a position to pay that, and we say that that's because it had been essentially stripped of its assets by the 4th defendant, who had transferred the first claimant's business into the 5th defendant, another DIFC entity. And thereafter, my client, the first claimant, was allowed to go into liquidation in this court, where the second claimant, also my client, a liquidator, was appointed by this court. And that's how I come to be appearing before you today, that the first claimant is in a DIFC liquidation run by a DIFC liquidator, who are all subject to this court's jurisdiction. And the second claimant is, in fact, an officer of this court. And as required by DIFC law, he has investigated the affairs of the first claimant and come to the conclusion that there are proper claims to be made against the defendants for stripping the claimant of its business. And those claimants have been brought in these proceedings. And they are brought as fraud claims, and they have obviously been signed off by counsel, bearing in mind that making allegations of fraud in this context is incredibly serious. And the way that the judge described these claims in his judgment, this is the second judgment, page 351, para 38. Your Honour may want to turn that up. That's page 351.
351, 351, 351, para 38, 351.
Yeah, and it's the last sentence. This is a claim which is alleged to be based on fraudulent activities perpetrated in the DIFC and based on issues of DIFC law with the removal of assets from a DIFC company liquidation with a view to avoiding payment of a judgment to which that company was subject. Does your Honour see that? And of course, that was a judgment of the DIFC court. Yes. So this case certainly came about because of a very strong DIFC connection. Let me just say a few words in a bit more detail about the nature of the claims, because they're all DIFC law claims. If Your Honour goes back to page 181, which is the first judgment of Sir Jeremy Cook.
181. 181. Okay.
Yes. And it's paragraph 20, and this is an extract from the summary of the petitive claim. And I'd be grateful if Your Honour could just read paragraph 20 and the quotation just down to the end of the small text, please. Down to paragraph 30.
Particulars, is it? The consolidated particulars of claim.
That's right. Yes.
Okay, which one do you want me to read?
Paragraphs 10 to 13. So if you can see there is a citation of those paragraphs.
Yes.
And I'd be grateful if you could just quickly read that.
BSA's business was transferred to the fifth defendant for consideration instead of the scheme was enacted for the purpose of allowing the fourth to relaunch its product. Never mind, it's a bit too complicated for me, quite technical.
Okay, well,
just go ahead. Quite technical for me to go very, very quickly. Yeah, it's really slowly to understand what he's trying to say there. But doesn't matter. You just go on.
Okay, so what
are you trying to say from this? What are you trying to say? Can you tell me what you want to say from this?
The central feature of any jurisdictional assessment and the court's assessment on which is the most appropriate court for the dispute to take place is an understanding of what the case relates to, and as a result, where it would be most properly tried.
Yes.
And Sir Jeremy Cook had obviously spent quite a lot of time with these pleadings.
And what did he conclude from there? There are in my number of features. This is what I meant. Number of features of action and insolvency in the FZ which render the FZ more appropriate forum than Geneva. This is the paragraph I meant. Then Geneva in the end of justice interests of parties, quite apart from the connecting factors of parties themselves. But it was argued on behalf of the claimants that Geneva was not, in fact, the available problem with the person with personal and subject matter jurisdiction. The evidence of this is what I was referring to earlier on.
So that's where these points go. So let me just, I appreciate there's quite a lot of material here, and that's one of the reasons why in my submission the time that Sir Jeremy Cook was able to spend on this matter, reading, going through the bundle, was obviously informed his decision, and it's not something that the Court of Appeal could fairly deal with, or Your Honour could fairly deal with briskly. It's something that needed to be looked at carefully at first instance, and it was. But anyway, the judge's assessment, and I've given you a nutshell of it, the nature of this case was about the asset stripping of a DIFC company that was subject to a DIFC judgment, where its business was transferred to another DIFC entity, where the fraud was carried out by directors of a DIFC company, and both the first claimant and the fifth defendant, i.e. the holder of the original business and the party to whom it was transferred, its shareholder was the fourth defendant. And so simply by understanding what this case is about, it's very clear that every single defendant and the substance of the case are wholly connected to the DIFC. And then just looking back at those paragraphs I asked you to read, paragraph 12 and 13, those claims are claims for breach of DIFC law.
Those claims are claims under the DIFC
law. Yeah, the DIFC claims.
Yes.
So, and we'll come back to look a bit more in detail at some of the claims, because I know Ms. Martin now says there's a limitation issue, but in a nutshell, we don't accept that, because these are fraud claims, and under DIFC law there is no limitation for fraud claims. But I'll come back.
So you are saying that between the two courts, Swiss, the Geneva courts and the IFC, considering the claims under 20, under 12 just now, the DIFC court is the more appropriate court to decide the dispute.
Yes, exactly.
Yes,
and I will develop that as well. So let me just tell you a little bit about how the Swiss claim came about. So my client, the liquidator, was appointed by this court to investigate the affairs of the first claimant, DIFC company. He decided that it was proper to bring claims. He has a duty to this court and a duty to creditors. And he decided it was proper to bring claims. And he sent a pre-action letter, which is the conduct that this court requires. And that was sent in February 2022. And Clifford Chance were instructed to act for all of the defendants, and they responded to the pre-action letter. And one of the things they said was that the issue of proceedings would be premature, i.e. it would be too early to issue proceedings. And so the parties agreed a standstill. Now, what Ms. Martin said about that standstill was correct. It technically didn't stop the defendants issuing proceedings, but of course the focus was always on the claimants, because it was the claimants who had threatened to claim, and the defendants had not sent any pre-action letter. So it's not surprising that the standstill was the standstill of the claims that had been articulated, i.e. the claimants' claims. Anyway, the parties agreed a standstill. They entered negotiations, which were without prejudice, and I can't talk about. And then after 11 months, while still subject to that standstill agreement, the defendants out of the blue issued proceedings in Switzerland. And they sent no pre-action letter and gave no warning that they were going to do that. It was done, as I said, out of the blue. And perhaps particularly telling, those Swiss proceedings simply relate to the liabilities set out in the DIFC pre-action letter. So in the Swiss claim, all they are seeking is a declaration from the Swiss court that they're not liable in respect of the DIFC claims. And we say that that claim in Switzerland was brought simply to disrupt the conduct of these proceedings in the DIFC. It was a spoiling tactic. And I will explain to you in due course why that spoiling tactic doesn't work as a matter of DIFC law. But it's important that this court, as I believe Sir Jeremy Cook was aware, understands what's going on here. The litigation tactics run by the defendant to avoid having to deal with these fraud claims against them in the DIFC. So I just want to develop my spoiling tactic point quickly. And there are 5 reasons why we say that this is a spoiling tactic. The first is that we sent our pre-action letter and that they never gave any warning of their Swiss proceedings. Now, we think it's particularly striking that when you read Ms. Martin's skeleton argument for this appeal, her chronology doesn't mention this pre-action letter. So she sets out the chronology of proceedings, and the chronology of proceedings starts with the Swiss proceedings and doesn't mention what had gone before. But we say once you understand what's gone before, you understand why the Swiss proceedings were brought. So that's my first point. My second point is that the Swiss proceedings are in their barest form. They contain no real particulars of the case. And critically, there is no explanation as to why the defendants say they're not liable in respect to these allegations of fraud. So the defendants chosen to continue to keep their powder dry. My third point is that even after the issue of the Swiss proceedings, the defendants didn't try to press ahead with those proceedings. In fact, it took them more than 4 months after issue to give us a copy of those proceedings, and we had to ask them for it. And even then, they're still not pressing ahead with that case. They could have drafted statements of case and set out their position in detail, and that would have obviously required them to particularize a defense.
Mr. Chief Justice, that's just untrue. That is just untrue. Please don't make that representation to the court. I won't interrupt you, but please don't make false statements to the court. Service lies with the UAE authorities. It is sitting with the Ministry of Foreign Affairs. The claimants have no control over it whatsoever. The claimants made claims consistent with Swiss practice. They are entirely serious claims, and we have no control over whether or not they are served. We have, in fact, attempted to contact the ministries to see if we could get them to expedite service. We've been unable to get traction.
I think that's fair for Ms. Martin to say that.
Yeah,
okay,
but
please drop that point and go ahead, Mr.
Well, actually, just on that though, Your Honour, what I said was actually completely true, and the way that I put it, and this is absolutely right, they could have drafted statements of case and circulated them in draft, but they have not done that. So my submissions were true, and I'm a little bit surprised that Ms. Martin would intervene to say to a fellow advocate that their submissions are untrue, but maybe she'll reflect on that. And then my fourth point is that the third defendant has an exclusive jurisdiction clause in his contract with my client, and that is an exclusive jurisdiction clause in favour of the DIFC courts. And the Swiss proceedings have been issued in violation of that. So those are my points about the spoiling tactics. I want to just make some other points about...
Okay. This exclusive jurisdiction clause,
yes.
I remember reading that as well. Where does it appear? Where does it appear in the judgment or in wherever?
It appears in the second judgment. I'll just grab the reference. Sorry.
Where is that? What page is that, please?
Yeah, sorry, I'm just grabbing it myself. Please give me a moment. So that's paragraph 20, page 347.
347.
And let's just turn that up. Page 347, para 20.
Para 20. Okay. Secondly, the third event is bound by exclusive jurisdiction clause. Okay. Para 20.
Yep.
Okay.
Yep. So that obviously is a really important point.
Second judgment. Or second judgment. Okay, let me read. The third event is bound by the exclusive jurisdiction clause, and the court would need very strong reasons to say will not keep to the contract. The claims against him for breach will all proceed against him when there's no reason why. Okay, that's good. Yeah, okay.
So just a few other points about the defendant's conduct that I think that obviously Sir Jeremy Cook, having heard a number of applications in this matter, has spent a bit of time thinking about. There are 4 points which we rely on to say the defendants have been trying to stop these DIFC proceedings progressing. The first is that they before their jurisdiction challenges, they sought to stay these proceedings on case management grounds. And the fifth defendant made an application to the court, was heard by Sir Jeremy Cook, seeking a stay of claims against all defendants pending service. Now, that application was rightly dismissed by the court and has not been appealed. So that was the failed stay application.
Stay on what ground?
Case management grounds.
Oh, case management.
Yeah.
Okay. Delaying tactics.
That was the first of the delaying tactics. Then there was another one, which is that after the court had listed the first jurisdiction challenge for hearing, the defendant sought a 3-month adjournment of that hearing. And again, that was application was dismissed by the court, and that decision wasn't appealed. Again, so that's a failed adjournment application, again, delaying tactics.
Okay.
Then the fourth defendant complained about service on it in Singapore and said that although the claim had been served on it according to both DIFC law and Singaporean law, that because it didn't comply with Swiss law, that service should be set aside. And that was also rightly dismissed by the court, and that has not been appealed either. And then finally, and we say this one really gives the game away, we have asked the defendants to confirm that if the DIFC law, if the DIFC courts decide jurisdiction in our favour and decide that the DIFC courts is the more appropriate forum, that they will not go ahead with their Swiss proceedings, and that they will wait for the determination of the DIFC proceedings. And they have not given that confirmation. So they're litigating all of this.
They have not given that confirmation. They have not given the agreement. So it's not an issue. To me, it's not an issue. If they don't agree, then there's nothing you can do about it.
No.
Okay.
No, exactly.
Yeah.
Exactly. So let's move now to the grounds of appeal. The first point is that the defendants don't seek to appeal any of the judge's findings of fact, and they're right to do that. As your Honour will know, trying to set aside a finding of fact by a first instance judge is difficult. It normally is analysed as an exercise of discretion, and so you would need to show, essentially, as your Honour said earlier, that no reasonable judge could have made that finding. Now, we say that in terms of the points that they are running on appeal, none of these are proper points of appeal. And the court will need to obviously consider each ground. Each ground applies for different defendants. So even if you think that one appeal ground has prospects of success, that isn't a reason to grant permission against all, in relation to all of the defendants. You need to look at them individually. And when we go through them, I'll tell you which ones apply to which of the parties. So let's start, if I may, with the mandatory stay point. Now, my learned friend describes this as the lis alibi pendens point. And I will come back to that terminology in a moment. This is the only ground of appeal that goes to all of the defendants. The other grounds of appeal don't apply to all defendants. And this is, in fact, their main ground of appeal, because if for some of the defendants, if they don't succeed on this, they are stuck with the DIFC as the jurisdiction, and they will simply just have to get on with the case here. Now, I said to you that there was this dispute about terminology, and with the greatest respect to the defendants, there's some litigation tactics here with the way they use lis alibi pendens, because my learned friend said the issue was whether or not there was a doctrine of lis alibi pendens, and that's not the issue. The issue is about whether or not a pending suit gives rise to a discretionary stay, which is what we say happens, or whether it gives rise to a mandatory stay, which is what the defendants say happens. That is the issue. And the judge's view was that it was a discretionary question, and he took it into account in his assessment, and we say that assessment was in the reasonable range of assessments a first instance judge could have reached. But the defendants go far further. They say that the existence of a foreign pending suit means that the DIFC court must grant a stay, simply because the Swiss court was first in time. That is the issue. And I'll explain to you why their position is unprincipled and is not supported by any authority. But let's just say something about the term lis alibi pendens. So your Honour, I think earlier noted that the Latin meant suit pending elsewhere. And that's all it means. There's no magic to this term. It's perhaps a fancy phrase for referring to a qualifying foreign legal proceeding. And it's used often in the authorities, lis alibi pendens or lis pendens, same thing. And and it's used generally to refer to pending suits elsewhere. So when my learned friend says we know that lis alibi pendens has real prospects of success as an appeal point, it's a skillful piece of advocacy, but actually on analysis it doesn't work at all. Lis alibi pendens is just a foreign pending suit. We know that the DIFC court takes that into account on a discretionary basis as part of foreign non-convenience. But my learned friend wants to go further and say that it's mandatory, that you have no choice. You have to grant a stay. And that's the point that I want to tackle. Now, the judge's approach to this was entirely orthodox. He found that the Swiss proceedings were a lis pendens under Swiss law. So let's have a look at the judgment. That's para 176. Sorry, it's page 176.
Page 176. 176. Okay, go on.
It's paragraph 6, right at the top. Do you see it says the conciliation proceedings under Swiss law constitute
176. The conciliation proceedings under any constitute lis pendens or the province.
So the judge recognised that under Swiss law these were constituted lis pendens pending suit, and then when he came to consider the position on the DIFC law, if we go forward to page 179. And para 17. Now this is para 17 is where he deals with the discretionary versus mandatory stay, and his conclusion is it's a discretionary factor, whereas the defendant's position is that it is mandatory. So they refer to this concept of the court first seized. I don't know if that's a concept Your Honour has previously come across. But it's the point they run is that what matters is which court, where the proceedings started first. So they say that if the court where the proceedings started first trumps the other courts. So if the Swiss proceedings were first in time, that is a complete answer. You are obliged.
There's only a factor to be considered. One of the factors to be considered is who filed the case where first. But yes, after that, there's so many other considerations that must be taken into consideration. And that's where the discretion comes in.
Exactly. That Your Honour is absolutely right. And that's what that's exactly how the judge looked at it. And that is, in my submission, consistent with the highest authority, the House of Lords and the Supreme Court. So Your Honour's view is absolutely in line with that. And if you look at para 17, the judge deals with this discretionary compulsory point. And could you just read that paragraph if you can? Just the bit at the bottom of page 179.
Yes, never the case listed on one count alone is nothing. Always the most appropriate in the interest of the parties and ends of justice. The party has never been Brussels regulation, Lugano, blah, 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 blah. Okay.
Yeah, that was the point. And we don't need to dwell on it, but the reason he refers to the Brussels regulation and the Lugano Convention is because in England, for the period that it was a member of the European Union, there was a regime where the cause first seized mattered. So there, when you were looking at European claims versus English claims, it did matter who had been issued first. And it's fair to say that a claim issued in a foreign state first would trump.
And then para 18 is very important. When connecting the factors are examined, the following points are evident. I think that's critical.
Yeah, it is. This is the judge's evaluation of the factors, and that is an exercise of his discretion.
Para 18, page 179. Okay.
Now that So we have no quibble with the idea that you would take into account the existence of a foreign proceedings, that you could take into account the date on which it was issued and how far it had progressed as part of a foreign non-convenience assessment. But the defense position is the judge erred because of this. They say the court first seized makes all the difference. They say that where a court of competent jurisdiction has been first seized, the DIFC court should give way to that court. Now, that they accept there is no DIFC law where this point has ever been found, and they can't point to any English authority where the English court did the same thing. And our position is this has never been the law of either England or the DIFC. But anyway, it doesn't matter what the law of England is. What matters is the law of the DIFC. Now, on this point, can we just look at what they say in their skeleton, because we don't think that they fairly characterize the judge's findings. If you look at, this is page 77 of the bundle.
77?
Yeah, this is the defendant's skeleton argument for this permission application.
Okay.
And it's right at the very top. They purport to quote the judge.
Page before. In
circumstances, no, well, it's just the end.
Rejecting
It's just the last line.
Yeah.
Do you see where they say the doctrine of lis alibi pendens has never been part of the law of the DIFC? Do you see that?
Yeah. What is the footnote? And that's a footnote there. The footnote, order 11, order 7.
Yeah, so it purports to be a quote from the judge's judgment, but actually it's not a fair quote. And if we actually looked, just before we look at what the judge said, I just want to pick up on the words before the quotation mark. So they say the judge's finding is the doctrine of lis alibi pendens, and then they start the quote, has never been part of the law of the DIFC. And that then let's look at what the judge actually found, which is at page 179.
179, okay. 17. Yes.
And it's the second sentence. He says something quite different. He says, not that the doctrine of lis alibi pendens has never been part of the law of DIFC. He says instead, it's never been part of the law of the DIFC that a case should be stayed on that ground alone. And I emphasize two words in that. It should be stayed, because this is the mandatory point, and then on that ground alone. And so we say it's unfair to suggest that the judge found that the doctrine of lis alibi pendens has never been part of the DIFC law, because that's not what he found. He was finding that the mandatory stay point has never been part of DIFC law, and he was right about that.
Okay.
Now, let's just look at the DIFC authorities, which will make good this point. Now, as Your Honour said earlier on, this court and the court below is very familiar with foreign non-convenience issues. It's in these international courts, foreign non-convenience often comes up, and quite rightly, the DIFC has a very advanced jurisprudence on it. And we'll start by looking at a decision of this court, the Court of Appeal, in the IGPL matter. And that's at page 1650.
No, just cite the principle to me. You don't have to refer to the cases for me, Mr.
Okay,
Sharif.
fine. So
just cite the principle. I mean, I'm quite familiar with most of the cases.
Yeah, okay, fine. So this is IGPL. It's paragraph 171. That's page 1650 of the bundle. And there the Court of Appeal held lis pendens and the risk of conflicting judgments are but two of the many factors which determine the suitability of permitting an action to subsist in a particular forum. So they just say lis pendens is a factor. It's a discretionary factor. We completely agree with that. And that is the law, currently the law of the DIFC. And then similarly in in the Union Insurance case, Justice Wayne Martin had to look at issues about foreign pending suits, and I'll just read out what he said there. So there was an argument before him that the court should stay the proceedings pursuant to the doctrine of lis alibi pendens. He said that in the skeleton, the applicant had accepted that lis alibi pendens was an aspect of the doctrine of forum non-convenience. Of course, that's right. He then explained that there was an issue in that case about whether you could have forum non-convenience issues where there were other proceedings pending in the UAE. So there's an issue about whether you can have where there's multiple proceedings in the UAE. And then he goes on to explain that he had some misgivings due to that aspect of it. So there's no question, we say, that the law of the DIFC is that lis pendens is a factor, but there is no authority that says that you are required to order a stay. And my learned friend referred to the Horizon case, but the Horizon case wasn't a forum non-convenience case. It was an abuse of process case. That your Honour may remember that from when you heard it, when you refused grounds an appeal on the grounds of lis pendens. But it was the point there was that there was a pending suit, and that was said to form part of the analysis of abusive process. So the lis pendens form part of the abusive process. Anyway, your Honour decided to refuse permission on that ground, but that case is not. There was no case, as far as we can see, in that no argument in that case that anyone was saying that lis pendens gave rise to a mandatory stay in relation to a forum assessment. That case was about something completely different. So look, just putting this point together, we say it's obvious why DIFC law is right and why the defendants are wrong. And that's because if Miss Martin was right, in any case where there was a prior action in a foreign court, the DIFC court would have to stop. It would have to give way to that foreign court. And that would essentially bring to an end much of this court's international jurisdiction. It would be an easy way of stopping these proceedings, because in the DIFC, you've got to send a pre-action letter. So you send a pre-action letter in the DIFC, the defendant's on notice of the claim, and then they issue anywhere in the world, in any court, however corrupt, however unsuitable, however inappropriate. And then they say, look, I've issued in an inappropriate court, but the DIFC court must stop. So we say it's obvious that this is not the law. It's never been the law in either England or the DIFC, and there's no serious argument about it. Now, Your Honour, I was about to move to the next point, forum, but is there anything I can help you with on that? No. I'm grateful. But sorry, just by maybe just as final point on that, because the Court of Appeal has already set out its position in detail in IGPL, and I refer to that Wayne Martin case as well, Justice Wayne Martin case. There is no need for the law to be clarified. There's no debate over this. There's no uncertainty. So this is a case where you can simply refuse permission at this stage, and if you want to do it in a written judgment, you can support. We say you can just simply support what the Court of Appeal has said before. And we also say that because of the defendant's delaying tactics, this is a case where you should act. You should refuse permission now. And not allow them to continue these mechanisms to stop the proper proceeding of these fraud claims. So that's the first point, lis pendens. The second point is forum non-convenience. Now, this is only a point run by the first to fourth defendants. It is not a point run by the fifth defendant. So if I'm right about lis pendens, the fifth defendant has no other substantive grounds of appeal. I mean, he has a relief from sanction application, but that only goes then to the lis pendens point. So actually, if they lose on lis pendens, the case against the fifth defendant, which is a DIFC entity, is going ahead in the DIFC. And we say that's a really important factor because actually properly analysed, a lot of this case is going to happen in the DIFC anyway. That's the first point. Now, there are 3 complete answers to the forum non-convenience proposed appeal. And they're each knockout points, complete answers. Now, the first is that, as your Honour will know, the Spiliada test involves 2 stages. The first stage is that the appellants have to show that the Swiss courts are an available forum which is clearly or distinctly more appropriate than the DIFC. That's stage 1. Then with stage 2, if they can satisfy you on that, it goes to a second stage where the court can refuse to order a stay on forum grounds on the basis that it would be unjust to prevent the claimant suing in the DIFC. Now, in our case, the judge found in our favour on both points. On stage 1, he found that actually the Swiss courts were not clearly or distinctly more appropriate. But he also found that if he was wrong on that point, that it would nonetheless be unjust to prevent my clients from suing in the DIFC. And the defendants have appealed the stage 1 finding, but not the stage 2 finding. And we've pointed this out to them, and even then they haven't sought to bring the point in late. We say they couldn't, but they haven't sought to. And that is a complete answer. That even if they were right, that Geneva was clearly or distinctly more appropriate than DIFC, the judge has found that nonetheless the case should proceed in the DIFC. And we'll just, if I just give, do you want me to just give you the references to the judges? We don't turn them out necessarily, but the judge found that at paragraph 24 of his first judgment and paragraph 21 of his second judgment. So that is actually that's a complete answer on forum. The second point, and this is a point I think your Honour relighted on earlier, that it takes a very rare case to overturn a first instance judge on forum grounds. And we've set this out in detail in our skeleton. And I'd just like to have a look at that. We can deal with it quickly. It's page 98 of the bundle.
Yes, go on.
Does your Honour want to have a look at that? Because we could deal with it very quickly.
Is this the point on RDC 44? Is that what it is? No?
No, it's not.
Okay.
This is a point about
what page is it? What page is it?
98.
98. Yeah. Okay. Yes. Okay.
So we can deal with this quickly by reference to our skeleton argument. Paragraph 28.
Mm.
The circumstances in which an appellate court will interfere with the judge's decision on forum non-convenience are few and far between. And in the Lubin case, Lord Bingham explained that differing conclusions might be reached by different judges without being susceptible to legal challenge. So the fact that a different judge might have reached a different decision is irrelevant for a forum appeal. And then if you go to paragraph 29, in Spiliada, Lord Templeman said an appeal on forum grounds should be rare and the appellate court should be slow to interfere. And then Lord Neuberger said in VTB, an appellate court should hesitate long before interfering with the judge's assessment. And then in paragraph 30, we set out the Aberdeen-Daver case. And there it was said that the appellate court cannot interfere simply because its members consider they would, if themselves sitting at first instance, have reached a different conclusion. And then these authorities just go on and on saying the same thing. Appellate court should be very slow. And your Honour described the point right at the beginning of the hearing very clearly. It is only if no judge, no reasonable judge, could have come to that conclusion that the appellate court would interfere. And we say that that's impossible to hit in this case. The judge was entitled to think the centre of gravity was the DIFC. I've explained to you why we say that was right. But we say it's not properly arguable that no reasonable judge could have decided that this case should be tried in the DIFC. So that we say it's a complete answer. And there, just if you go over the page to 99, there is this DIFC authority on this as well. And that's the Pro-TV case.
Productivity. Okay.
Yeah.
Yeah, I've gone.
So this is, again, it's all very orthodox stuff,
Okay.
we say. And then my third point is a point in relation to the third defendant. I've said to you that he had an employment contract, which included an exclusive jurisdiction clause in favour of the DIFC. And I've already taken you to the judge's judgment where he said, where he found that that was obviously an important factor. And there, we don't need to get into the legal standard, but it's obviously much higher, where someone has written, agreed in writing to the DIFC being the applicable court. The circumstances in which the DIFC will then refuse jurisdiction are always going to be very rare. So we say, again, that for the third defendant, that's a complete answer to the case against him. So for those three reasons, we say that the foreign non-convenience points are dead in the water. Can I then come to the final appeal point, the extension of time? This is only a point that goes to the first to third defendants. So this will not stop the case progressing against D4 and D5 in the DIFC. Now, the defendants do not seek to appeal the judge's factual findings on this. And that's key because, as Miss Martin said to you earlier on, she accepted that this was an exercise of discretion. And she said to you, my note says, it all depends on the facts. I think that was her language. Someone could correct me if that's a misquote, but that was the note I took down. Now, the defendants raised 3 points, and we say they're all bad points. The first is that this alleged limitation point, and they raised this point only in relation to our insolvency claims. Now, we can just look again at those insolvency claims. It's in the judgment, so it's easy to look at. And that's
no, just read for me, please, Mr. Sheriff. Just read for me.
So this is the judge cites this in his judgment as to he quotes from the summary of the particular claim. So that the insolvency claims against the individual defendants are, and I quote from the summary of the particular claim, for fraudulent breach of duties owed to BSA, for transactions in fraud of creditors, and for fraudulent trading. And it won't come as a surprise, each of those causes of action have the word fraud in them. And as Your Honour knows, and I don't believe there's any dispute over this, that for causes of action based on fraud under DIFC law, there is no limitation period. Article 9 of the Law of Obligations.
Yes.
Now, my learned friend, in their written argument at first instance, said to the judge that there was a dispute over whether these claims are properly characterised as fraud claims. That case was never developed in front of the judge. It wasn't raised orally, so they didn't pursue it before the judge. But the judge anyway found he himself described these as fraud claims, and he did that at page 178 of that judgment. And he found that there was no limitation issue. And of course, he was right to, for the reasons I've just explained. Now, the way that my learned friend runs it on appeal is a bit different now. They put a different case. They say that we, the claimants, do not advance these claims as fraud claims. That's the way they put it, paragraph 31 of their skeleton argument. But that's wrong. If you look at the reference that my learned friend cites for that, she cites Mr. Baganza's evidence. That's a statement filed on behalf of my client. And he says there, limitation under Article 38 of the court law would have expired on the 21st of February 2023, but for the fact that they are claims arising out of fraud. So he explains, because these are fraud claims, that limitation, 60 limitation period doesn't apply. So it's wrong to say that we haven't advanced these as fraud claims. That has always been our case. And they are also properly characterised as fraud claims, as the judge found. So their new point on limitation is a bad point. And in any event, just one final point about this. It's a really academic point, because we have started these fraud claims by way of insolvency application, and that under DIFC law starts with a different process. And we have served that on all of the defendants, and that case is progressing. And they have not challenged service, and it's now too late for them to do so. In the alternative, yes,
I think you're quite clear on this already. I want this clarification. If the permission is granted, then it goes to appeal on these issues. But then there's still that substantive case pending in the court of first instance, isn't it? The suit will continue. So, but if
it won't continue.
Will be stayed.
It won't be stayed, but it will be, yeah.
Will be stayed until the
procedurally,
disposal of this appeal.
Yes.
But if this permission is not granted, then you go straight back to the court of first instance and proceed on with a substantive claim, isn't it?
Yes, exactly.
And it goes before the same judge again most of the time, before Judge Cook again. Okay.
Yeah, and your Honour's alighted on an important point. The reason that we care, and I say this bearing in mind my client is an officer of the DIFC court, the reason we care is because these are claims that we think we have to bring in the DIFC and that we want to continue them. And what the defendants are trying to do is to stop the progress of these claims whilst pushing ahead with their claims in Switzerland.
Okay,
and you heard from Miss Martin earlier on about what she's trying to do.
I think, Mr. Sharif, I've heard enough from you. Can I ask Miss Martin whether you want to reply to what the issues raised by Mr.
Your Honour, there's just one point of clarification that I think I should just mention, which is that my learned friend referred to the Qatar investment case.
Yes.
And I don't think, I know it's always difficult when one's on the hoop, so I've made no criticism of her, but I don't think she correctly described the facts of that case. And I think I just want to clarify that, because I don't think it was very clear from my intervention either. What happened, all of these cases depend on their own facts, and they're all exercises of discretion. So, I mean, you don't get very far by comparing facts, to be honest. But anyway, in that case, what had happened is the claimant had basically done nothing, or done not very much, because of COVID, principally because of COVID. And very shortly before the expiry of the claim form, they made an ex parte application, so without notice application, before the master to grant an extension. And the master granted that extension. The parties then came back on an inter partes basis to set aside the original extension, and it was set aside after an inter partes hearing with lots of detail. Now, that was an exercise of the judge's discretion on the facts, and then the disgruntled claimant went to the Court of Appeal to challenge the master's exercise of discretion. And the Court of Appeal said, it's an exercise of discretion. You've just got to leave, whichever way it goes, you've got to just leave it to the master. So I just wanted that to be clear, because I felt it didn't really come across very clear from earlier on.
Thank you.
But
thank you.
Apart from that, I will stop. Unless I can help you, I will stop.
That's all. Thank you very much indeed. Miss Martin. Sorry, Miss Martin, your name is Miss Martin, not Miss Heather. Your Christian name is Heather. I'm sorry. I kept on addressing you as Miss Heather. It should be Miss Martin. Yeah.
Chief Justice Azmi, I've been in the region long enough that I certainly respond to Miss Heather.
Okay, thank you very much.
Thank you for the opportunity for rebuttal. Now, as Mr. Shivji rightly pointed out, we are not principally appealing facts here. Now, there are some facts that have to bake into these analyses, but we didn't focus on a factual recitation of the case for that reason. And so he put forward his reasons, as he should on behalf of his clients, why there are DIFC connecting factors. But allow me to describe the case to you in a different way. This case is about a Swiss bank and its Swiss resident employees who, and bearing in mind that all three of the individual defendants were simultaneously employees of the Swiss bank at the same time as they served as directors and respectively officers of BSA, the DIFC entity. So whilst Mr. Shivji showed you the third defendant's employment contract in the DIFC, let us please allow us to show you his employment contract in Switzerland. This can be found at pages 630 to 642 of the bundle.
630, is it? 630.
630 is the first page, but if I could take the court to page 640, and my apologies if I'm being confusing.
640, I think that's where I go to 640 straight away. Okay. Okay, 640.
And paragraph 16.
Hang on. Page 6 for paragraph 16, yes, governing law jurisdiction.
I think I'm sorry to intervene, but I think the way that my learned friend introduced this might just lead to confusion. She referred to the third defendant's contract of employment in the DIFC and Switzerland, but they were with different entities. It's a really important point. So the DIFC law contract was with my client, the first claimant. So as between us, there is a DIFC exclusive jurisdiction clause. This is this is an employment contract between the third defendant and the fourth defendant. So this is between the defendants, not between the claimant and defendants. That's an important point.
And of course, that brings into question on whose behalf actions were undertaken and whether or not they are governed by the employment contract at all. But nevertheless, the dispute concerns the actions of the shareholders of BSA, including the fourth defendant and one who is unnamed in this suit, that were taken in the windup of BSA. Now, what Mr. Shivji's clients complain of is that in effecting the windup by vote, by resolution, by proper governance measures, there were omissions in what they did, in that the individual defendants as directors did not, and I think the phrase they used is procure a sell of the business. And just to be clear, they say sort of off the cuff periodically that there was a transfer of assets. There was no transfer of assets. BSA had very limited assets. It was some cash and a few other things, but those stayed in the accounts the entire time. So what they're really complaining about is what happened to the business in the course of this windup. Now, that was the business of the shareholders. And so as it relates to all of these defendants, that was the business of the fourth shareholder sitting in Switzerland. And so there perhaps is an outstanding justiciable question about what, if anything, the individuals should have done. Was there anything within their power that they were required to do? But that does not place the center of gravity of these events in the DIFC. It places the center of gravity of these events in Switzerland. So these Swiss parties had very good reason for bringing their claims in Switzerland. Lord Goff, again, when he was arguing what ended up being the Spiliota standard, but in the Atlantic case, recognized that claimants will generally prefer their home jurisdiction. This is not some case of gross forum shopping, going off and finding a forum that has nothing to do with the facts of this case. This is claimants suing in their home jurisdiction for actions that they took there. As to delay, the claimant sat on this case for almost 6 years before issuing their letter before action. They did as well, at least as the liquidator, he did very little to progress the liquidation. Our client, the fourth defendant, is a creditor of the estate. They received very scant updates from him. And then within 3 weeks of losing some claims, and we will get to the fact that they would lose some claims if the statute of limitations were to run, they issued the letter before action and asked for a standstill agreement. And one only need to think, what would be the reason for putting in place a standstill agreement if they weren't going to lose claims on the expiry of the limitations period? There would be no reason. They know that they would lose claims but for that expiry. So Mr. Shivji is right to say that the negotiations took place during the course of about 11 months. And he's also right to say that they were without prejudice and that he can't refer to them. But by representing to the court that they were surprised by the issuance of these claims, he is misrepresenting what happened during those without prejudice negotiations. And if he keeps doing this, because the claimant side keeps doing this, tacitly making reference to things that happened during without prejudice negotiations, and then claiming to have a different state of knowledge before this court, I'm going to file an application, because it's really untenable for him to keep doing this. These were not issued out of the blue. The liquidator was well aware that my clients considered Switzerland to be the more appropriate forum. This should have been no surprise, and if it was a surprise, again, it's just because they were poorly advised. So as to who has been delaying what, since the issuance of proceedings, the defendants have participated in these proceedings, whereas, and they've been criticized, by the way, for demanding service in compliance with Swiss standards, even though that is the rule of this court, that defendants have the right to demand that. And they've been saying that's a delaying tactic. So when the fifth defendant was served first, and it came in and was like, hey, I don't really have any facts here other than the fact that I'm accused to have received some monies by the virtue of the actions of other people, I think it makes sense for the case to be stayed to allow the other defendants to catch up in service, because it was, again, the claimants who delayed effecting service by months and months and months. And rather than taking a sensible view of allowing the defendants to catch up, the fifth defendant was cast in a poor light, and then the fourth defendant, same thing, while the other defendants were caught up. Now, all of the Swiss defendants have been criticized by the claimants for having demanded service in compliance with Swiss law, but you'll note that the claimants here are demanding the very same thing when it comes to service in the DIFC. And in so much as the court of first instance noted that service may be dilatory by when court assistance is required, the Swiss were really quite expeditious about it. Once they got a hold of the pleadings, the defendants were served within a matter of months. The UAE authorities have been sitting on this service since July. It took Switzerland a couple of months to get the service documents to the UAE. Again, activities entirely outside of the control of the defendants. But the UAE authorities have been sitting on it since July, and we can't get them to do anything to speed up service. There is no delay. These are just the matters as they have unfolded. Yeah. So going to Mr. Shivji's claim that the Geneva proceedings were filed to disrupt the claims here, no. The Geneva claims were filed because the defendants believe that Geneva is clearly the more appropriate forum to litigate these actions that took place in Switzerland with Swiss resident parties. Again, the criticism that they were not particularized. This is per Swiss practice. In Swiss practice, there's a mandatory mediation process at the beginning of any claim. This is how claims are brought. So moving on more properly to the points of appeal. And Mr. Shivji's claim that Liz alibi pendens is not a doctrine and that's some sleight of hand by us for advocacy purposes. It is referred to as a doctrine by this court in the Horizon cases. That is where we latched on to the terms. We would vehemently dispute Mr. Shivji's claim that we know the DIFC court takes Liz pendens into account in forum nonconvenience. The matter has never been considered in any case where proceedings are pending in a foreign jurisdiction. The case that Mr. Shivji cites to, IGPL, where he said, it is the law of the DIFC that Liz pendens is taken into account in forum nonconvenience. Well, it simply can't be the case. That issue cannot have been decided in that case because that case considered other proceedings in the UAE, namely Sharjah courts. And so this was not a justiciable question presented to the court in that case. Again, as to his claim that it is only a factor, then if that is the case, this court needs to clarify it. That there are and that this would be a compelling reason to grant appeal under Rule 4419B. The Union case, which he also cited, is also not an international case. We did a thorough scrub of the law of the DIFC, and the question simply has not been decided. And it is open for this court to adopt a different standard than the standard used in England and Wales for the reasons that I articulated. And it's not that we don't rely on any authority. It's just that Mr. Shivji has a very English-centric approach, and we don't rely on an English authority. But this court is well within its right on relying on the unidroit principles. It is within the character of the court to do so. In certain instances, it relies on UNCITRAL models. There's no reason that it couldn't also rely on a unidroit model here. Now, Mr. Shivji catastrophizes what could happen if this were to become the law of this jurisdiction, that a vexatious defendant could file a suit anywhere in the world that would disrupt the jurisdiction of the DIFC courts. No, there are still safeguards on the standard that we would ask this court to adopt. Those are incorporated, again, in the unidroit principles. They require the court to be competent. They require it to be obvious that the court be able to make a finding that the alternate court could resolve the issues. And so we are not talking about filing proceedings in North Korea. This is Switzerland. The trains run on time. The watches are known to be world class, and the courts have been around for hundreds and hundreds of years. As to the forum non-convenience point, we don't read the judge's judgment as making a finding on injustice, which is the second limb of Spiliota. He really made it entirely on the first limb, which then, he decided it on that basis. So I don't, again, Mr. Shivji, as I recall, in our prior arguments, when we disputed him on injustice, again, because we're talking about Switzerland here, he said that that was not the argument that he was running there. And I would suggest that the court of first instance found no injustice that is likely to be affected on forum non-conveniens. What we do say about forum non-conveniens is, again, if it is the law of this court that lis pendens is a factor to be taken into account in forum non-conveniens, that has not been decided. That is not clear. I would not have advised my clients to run an independent lis pendens argument if that point of law were clear. And it merits clarity because it gets expensive for clients to litigate these matters when they are not clear before this court. We would further state that the court really granted no weight whatsoever to the fact of the other pending case. I think that the court entirely bought into the reasons that Mr. Shivji put forward, that he believes that it's just a disruption tactic rather than a real suit meriting consideration. And also gave no consideration whatsoever to not really just the likelihood, but almost the certainty of inconsistent outcomes as between the courts. You just pause 1 minute. Further, if Mr. Shivji is truly concerned that Swiss courts do not have jurisdiction, the Swiss courts will say so. And if the case is stayed here, the case will come back here. So there's no doubt that the case will be able to be resolved by a court of competent jurisdiction, even if this case is stayed, as the defendants have requested. Now, going back to what was my original first point, the extensions of time, when Mr. Shivji quotes me on saying it all depends on the facts, that was in response to a question from the court specifically about how long of a delay is too long. And whatever the answer is, I don't know that there's a bright line rule, because I think it depends, again, the relationship between countries where service is being affected and the service mechanisms that are at play under the circumstances. But here, where service out require judicial assistance, 4 months delay of a 6-month service period is too long. They needed to start earlier than that. The fact that they ran out of time at the end has nothing to do with the conduct of the defendants or a lack of cooperation from the defendants. It wasn't incumbent upon the defendants to do anything other than pick up the documents from the Swiss court by the 9th of August. They themselves did not have a 1st of August deadline, and it's anathema to justice for them to have to bear the claimant's responsibility. As to the claims that would be time barred, there are claims that are not brought in fraud. Transaction at undervalue does not sound in fraud. Claim for company property does not sound in fraud.
That's those who would, just to correct my friend on that we were talking about the claims against the first to third in insolvency, and those are fraud claims, and I read them out to the court. So she might, if she's going to take this point, she needs to identify the claims against the right defendants.
Well, there's a vicarious liability claim for BJSS, and that certainly can't arise unless it is for the vicarious liability of the individual defendants. That does not sound in fraud.
Well, that can be cited by the courts at trial, whether, you know. Anyway, yes, go on.
But the defendants would be deprived of putting forward that defense because it is an affirmative defense that needs to be raised along with defenses. And if the court's decision is that the extension of time is granted, then that effectively extends the time of that statute of limitations as well and deprives the defendant of that defense. It means that they can't argue that, at least in a meritorious way. And it is that deprivation that affects the prejudice on the defendants, as we stated in our first point on Liz alibi pendens.
So,
just in summary, I would just like to bring the court back to one of the cases we referenced, which is the Al-Zadra case, and at page 1864 of the bundle.
1864. 1864.
At paragraph 82.
1864. Yes.
They noted that it is important that the claimant's evidence in support of an extension is scrutinized with care. That is the standard that they cited from an earlier case, Hadanat. And they state, in my view, the judge did not scrutinize or pay sufficient regard to the following facts and matters as they emerge from the evidence, including as regards to, to delays ensued after the expiry of the limitation period. So this
where are you reading from? I missed 1864 paragraph?
Paragraph 82.
82, okay. As emphasized on the claimant's evidence in support for extension. Again, it's based on facts, different.
But you have to be able to scrutinize the facts. The court has to be able to, and they can only scrutinize the facts if they are evidence.
But Mr. Sharif will say that the judge had scrutinized with care.
But
listed in paragraphs 8, 19, 20, 21, all the details. I mean, it's again a question of fact. Yeah, okay, go on.
But again, these cases require the claimants to put forward evidence, not just a witness statement. The witness statement needs to be supported by documentation. And they didn't do that here. They refer to many documents, but they don't actually supply the documents. They say they needed funding, but they don't say how much. They don't say what it was for. They say that they had all these difficulties with translators. We don't have the documents to substantiate that. And again, there's a 2-month delay that they just don't explain whatsoever. It's just a 2-month gap there. Of 6 months, that is 1/3 of the time that they had to serve this. So the court asked for a case that had the most similar facts, and we would draw the court's attention to this case. There's a good summary of the decision at paragraph 89. It states, in my view, the overall position on proper analysis can be summarized as follows. First, the judge placed undue emphasis on the fact that the defendants had been unresponsive in circumstances where the claimant's solicitors had not taken the elementary precaution of taking expert evidence as to UAE law. Second, and going back to that first point, the claimants here did take Swiss law and then they sat on it for 2 months. So second, the judge failed sufficiently to take account of a very significant period of delay, both pre-issue but partially post-issue, the lack of any satisfactory explanation for these periods of delay. Again, here, we don't have a satisfactory explanation. We just were told that they happened. And the fact that the majority of the delays were attributable to the failures, inaction, and general lack of urgency on the part of the claimant's solicitors, as is apparent from the claimant's own evidence, in particular, a witness statement. Third, the judge also failed to pay sufficient regard to the expiry of limitation period and the fact that the claimant had chosen to issue the proceedings at the last minute. For these reasons, or rather it goes on to conclude, in my view, for these reasons, this appeal should be allowed and service of the proceedings against the 1st to 6 defendants should be set aside. This is an overturning of a prior decision based on discretion, based on very similar facts to what we have here.
Yes. Okay, what's the name? Al-Zahra. Okay, 1-8. Yeah. Excuse me a minute. I need something. Yeah, okay. Yes. Anything else, Ms. Martin?
I just to make sure that the court was clear that we were not abandoning the relief from sanctions point. The reason we haven't focused on it is solely because it doesn't get the 5th defendant anything unless the court is minded to grant appeal on the Liz Al-Baipendin's point. We do believe that the court erred as a matter of law in that he didn't uphold the standard in Denton for granting relief from sanctions. Yes. The pleading at issue was filed 3 hours after the 4 p.m. deadline. We believed we had an understanding with the claimants that they would not take a position that it was due at 4 p.m. because we had a prior agreement that that deadline would essentially be suspended until the court ruled on the stay application. They subsequently reneged on that agreement, and so we were left with a contested application. While we find their litigation tactics to be distasteful, we accept them and we accept that it was our responsibility to have served it on time. Nonetheless, Denton says that where the delay is not serious or significant on a pure case management application such as this, that should be the end of the inquiry. For whatever reason, it was not the end of the judge's inquiry. He went on to say that the interest of justice meant that he only needed to grant it if he was minded to grant the jurisdictional relief, which he was not meant to do. So he also didn't grant the relief from sanctions. This is further prejudicial to the defendants because the claimants have now taken the position that the 5th defendant has defaulted on all defenses. I don't think that the court below bought it because the court did set a provisional timeline for the filing of defenses, including for the 5th defendant, but still, it is exemplary of the type of prejudice that the 5th defendant suffers because of the denial of this relief that was clearly entitled under the Denton standard. And in any event, is necessary if the court is minded to take up the Liz Pendon's point.
Okay, thank you very much. That's all?
That's it for my rebuttal. Thank you.
Thank you very much. I'll give my judgment now. As we all know, as lawyers and judges, that arriving at a conclusion, there are two things that we have to decide, even as law students. First is facts, and then how the law is applied to the facts. If the facts are decided against you, you lose the case. If the facts are in your favor, then use law to rely on. So I'm doing the same here. I'm looking at the facts and then at the law. And that is why, Ms. Martin, I've went through many times. I'd like you to bring to attention the facts, how. But I couldn't, the facts have to rely as the judges found them. And as the judges found them, I'm strongly persuaded by what the judge found, that the center of gravity of this case is the IFC. And he listed this out, why he thought the IFC is the right court in paragraph 19, 20, and 21 in detail. So I cannot reject or cannot, I'm sort of agree that his findings of facts are correct. And then we come to the first of the three grounds, and that is the extension of time. And all the cases that have been cited just now relate to discretion. I cannot find anything wrong with the finding, the decision of the judge relating when he decided to grant the extension of time. I mean, you may not agree with him, but I cannot fault him on that. Then comes to the other two other issues, namely the lease pendants or lease alibi pendants and the forum non-convenience. Again, this is a question of discretion. And the judge has decided that between Swiss court or the court at Geneva and the IFC courts, the IFC courts is the more appropriate court that the case should be filed in. So based on those three items, and I do not need to go into detail of the cases as has been cited by both parties, as you will notice I comment as we went along to the cases. And so I dismiss this application for permission to appeal, and I award costs to the respondents. Did I see a submission on cost, or is it another case?
No, you're right, Your Honour, you did. We filed, in accordance with the rules, we filed a cost schedule, which should be in your bundle at page 2078.
I would like parties. Is it possible for you to agree on costs? I normally don't like to make a decision on costs. If you can't make a decision, I'm going to send it up to the registrar, send it down to the registrar to decide.
Yes,
but
that's fine. Or if you prefer, you could send it to Sir Jeremy Cook. I'm in your hands, because he has already assessed costs at a number of hearings.
No. I don't think it's right. I don't think it's right for me to send to Sir Jeremy Cook. I'll send to the registrar to decide on costs, and unless parties agree. But before we end this hearing, I'd like to say thank you very, very much to Ms. Martin and Sharif. I know at every hearing one has to win, one has to lose, but I am grateful to Ms. Martin for highlighting a lot of the case well presented, and again, law very well cited, referred to. And thank you very much to you, and also thank you very much to Mr. Sharif. I had enjoyed hearing your case today, and all the best to you. The weather is not too good outside there. I could see a bit, So
well, thank you. Can we both thank you just for sitting longer today? I'm very grateful that you took the time, and I'm grateful to Ms. Martin as well, as you say, for taking you through the authorities, and that definitely saved time. So thank you to you both.
The delay is my fault, because I was asking a lot of questions. You were taking me into detail, but I feel whenever a judge delivers a judgment, at the end of the day, only God knows whether his decision is right. But in his mind, he's done the best, consider the facts fairly, honestly, apply the fact, the law as he understood it to be, and arrive at the conclusion. And if I feel like that, then, you know, and I hope, Ms. Martin, you have been given a fair hearing for your case.
We thank the court for its curiosity.
You must explain this to your clients. So, and now the case will go back to before Judge Cook to hear the substantive matter disputes. Okay, so thank you very much indeed again. All the best. Have a good day.